Respect us enough that if we come into trying to help you guys, respect our time. No, we don't sit on social media all day. No, we're not obligated to answer your questions on a post. We're not. One of my social media pages, you can't even leave a comment. And in a second, all of them are about to be like that. I don't sit on social media all day. I'm not sitting there waiting to answer a question for you. And half of the questions that you guys are asking, the answer is already there. Listen to the video more than once. If you listen to a 4-hour video in exactly 4 hours, you didn't get anything out of it. You got to stop it. You got to pause. You got to write it down. You got to digest it. You got to take a break. So do yourself a favor that if this is really what you want, that you're going to put the work into it to do it. Okay. I think a lot of people are getting mixed up with this process. One, you're listening to too many people. You on every post. I see a lot of y'all on almost every post and on everywhere. And I think that it's hilarious. And then you come to me and say, well, is this right? Because such and such said this. But guess what? If you actually read it, you will know if it's right, because all you gotta do is read it for yourself. Okay. One of the biggest misconceptions it is that everybody running with this, the United States is responsible for my bills. FYI, they're paying them. Every single one of them. What you have to understand is that every contract that you sign, you gave them permission to do everything that they are doing. Everything. Go read your contract, right? But when you understand their words and their terminology, and you guys understand what's really going on, then you'll understand why we teach the way that we do. You guys hear me talk about securities fraud all day. You don't hear me talking about no 15 USC 1692 or 1681. Only then if we're dealing with a credit report. But if you're dealing with a mortgage, you're dealing with a car note, you're dealing with student loans, any retail installment agreement, you have to look at it for what it is. It is called securities fraud. Okay. When some of you guys have asked for documentation for some of these corporations, and you'll say, give me the documentation according to GAAP. I need the public and the private side. They ignore you, right? They act like they don't know what you're talking about. So I'm gonna show you that with the proper terminology, there is an accounting on the private side. And I'm gonna show you guys what it looks like. I'm gonna show you guys that it is securities fraud, and this is how they're doing it. They're getting away with it because they're all foreign companies, the way that they are registered. And according to the Security Exchange, if they are considered foreign, they do not have to report their securities. So they're getting by without reporting their securities. But more importantly, they're evading taxes. The IRS and the IMF, they're not a respected person or business. They want their money. And these companies are evading taxes. The reason that I say that this is much bigger than just debt, and it's much bigger than you just getting the title to your car and your little down payment back, right? Or you're getting the deed to your house and no money back. You guys are good with that. But after this class, we're gonna see if y'all really still gonna be good with it, okay? I'm gonna share my screen and I'm gonna show you guys something.
Hands out and prepare your jaws to be on the floor.
Yeah.
I can promise you
your
that.
jaw's about to drop. And this is why I'm always talking about it's collect the bag season. Okay. So this right here is the accounting that you guys are asking for on the private side. This is actually a forensic audit that was done on a mortgage, okay? It was done by a certified loan auditor. So we'll start here. One, I'm always talking about is the security, because what does this say? Securitization and the participants, okay? It gives you the borrower, the co-borrower, the current address. I did remove their information out because this does belong to somebody. Went too fast. So this is where the mortgage started. This is the date. This is where the note went to. Then it got transferred down to a trust. So for you guys that have been with me for a minute and I've showed you those SPG global forms and I say they
Mhm.
transfer from one company to another one and they always protect their money by putting it in a trust, which is why I've told every last one of you guys to put your life inside of a trust, the same way these companies are doing. Okay. So
And
it started here.
can I interject real quick?
Absolutely.
So you guys are wanting help finding the trustees, right? Understand only trust can deal with trust, and they are moving these things into private trust, right? So when you are searching, a lot of times you'll see, like for Discover Card, they are operating out of Discover Execution Note Trust, and you'll find the indenture agreement between that trust and the indenture trustee bank, right? And when you look at that form on SP Global in the flow chart, it's because it goes from the depositor to the trust. So the trust has the agreement with the indenture trust bank, right? So when you're looking, you can always find it most likely connected to a trust. So if you can't find it under MasterCard, search MasterCard Trust, SP Global, MasterCard Trust, Securities Exchange, right? If you type in that trust portion, it'll help you along. But that's all I wanted to say.
Absolutely. Right. So if you're new in here and you need to understand a little more, the reason that the all capital name letter was created is only a corporation can deal with a corporation. And as Caleb said, only a trust can deal with a trust, right? So you are the agent for the principal. I know a lot of y'all know what that means because y'all see it on the paper. Agent to, what is it? Notice the agent,
Is notice to
principal.
principal, and notice to principal
See,
is notice to agent.
okay, so what he just said, because I've never written that. So basically, when you write that, if you're the agent for the principal, you just wrote a letter to yourself. Or you think they keep ignoring them, right? Because the principal is the all caps, and you are the agent for that all caps. Okay, so that's why as soon as they see those terms in your paper, they laugh. They say they still ain't got it. Okay, so once again, this document came from a certified forensic auditor. And they are considered expert witnesses. We are able to use these when we are taking these corporations to court. So there's the FHA number, there's all that good stuff. But let's go down some more. So you see, it started with Jenny Mack, but this is the sponsor. So Securities LLC, the co-sponsor is Michelin Financial Group Incorporated. The trustee, Wells Fargo Bank. The tax administrator is always the trustee. So y'all remember when I just said they're violating the tax laws because they're not filing taxes. And this is why I always tell you, forget the CEO and the CFO, go straight for the trustee because they are the ones that are lawfully responsible for transferring the securities. They are the ones that are responsible for paying the taxes. They are the ones that are responsible for they are the ones that are responsible for the cancellation of our debts with that 1099. They have till March 31st of every year after the tax filing year in order to get those done. So we're not just telling y'all to look for the trustee for no reason. They are the head honcho. So that's some stuff y'all need that really don't make a difference. Let me get down to the good stuff. So just like I've showed you guys, there is a way that the note moves. When you are getting these audit reports done, it shows you how it was moved, how it went from the person, they turned into a deed of trust, it went to the lender, turned it into a mortgage, it went to Jenny Mae, they put it in the trust, then they circle back, right? And then they took the note, once it has been securitized, they took it and they gave it to the investors. This is where it comes when I say they're selling your securities. They start selling it here after they transferred it, protected it, securitized it, and then now it's good for the investors. Okay. They are doing this with everything that you sign. Job applications. If you know what the meaning of application is, you will know that any job application you've ever filled out is a security. This is the reason why they say that we're never supposed to be denied credit because as soon as you fill it out and sign it, you turn it into a security and they're going to sell it to the investors, okay? Now let's go down. So you guys hear me say that because we are considered minors, they are considered custodians. So the mortgage broker, they put unknown. But if you, then the mortgage broker took it to the lender, gave it to the borrower. Then the lender sells the loan to the issuer. So they sold this loan to the issuer, to which means they got paid for it, right? So the borrower obtains the loan from the lender. It can be done through the mortgage broker. And then the lender sells the loan to the issuer, okay? And they are considered the custodian. Loan documents on behalf of the trustee. The reason that they are a custodian because you went in there as the agent for the principal and your principal is a minor, especially if you haven't put it back on the record with your age, your majority document, and then you put your birth certificate back on the record, which is ultimately why the first class we did was the recording national status / do not detain, because all of it ties together. But until then, you're considered a minor and everybody is considered your custodian, okay? So this just says, can anybody tell me what they think this amount right here is? It's just, you can guess. Nephew, somebody put their hand up because I can't see it.
Okay, let's see if any hands. Anybody want to guess what that number is right there?
Latia, how just Letitia.
All right.
Hi, y'all. Yes, it looks like $518,335,496.
Okay. And where do you think that number came from?
All the trading and selling of the securities.
You are absolutely 1,000% right. This was a under $200,000 mortgage that at this time they have made $518 million off of one signature and one sheet of paper. And I'm gonna show you how they did it. Hold on. All righty. For anybody that know about the Bloomberg report, okay, we all know about the CUSIP number, right? This is how you get your CUSIP number, by getting a forensic audit ran. So this is the CUSIP number that was developed off of that one document that she signed, okay? At this particular time when it was ran as of November the 27th, this was the balance, $488 million. By the time they got done transfer some money out, it was worth $356 million, okay? You see where the trustee bank is? I just showed y'all up top who they said the trustee was, who was the servicer banks. Here it is, it's Wells Fargo. Because in order for a security to be turned into a securitized instrument to even develop the number, it has to go through your bank. I keep telling you guys, your bank is your middleman. You're not getting to the treasury without going through your bank. If you want to fact check me on that, go on to treasurydirect.gov and it will tell you that if you have any issues with your securities, it said, please do not contact the Federal Reserve or the Treasury or Janet Yellen, as y'all know her. It says, go to your financial institution. Y'all see why? It tells you when it's going to be paid again. So this number right here will continue to drop because they paid it out. They received it on 11/30. They paid it out on 12/16. Payday is the 16th of every month. The pays is done every 2 weeks. Let's go down some more. So they then sold the security some more. So this is where that $518 million came from, because this was the amount of the note. You see how many times they selling your signature? And then they have the audacity to say that you owe them. They have the audacity to foreclose and repossess when this is what they are making off of every sheet of paper that we sign our name to, because we're considered chattel paper and we lack
Oh,
certain
I'm
knowledge
glad you
to
said that.
understand how it works. Oh, you got something to say, nephew? Go ahead.
It's going to come up later in the lesson, but I'm glad you said that. Shadow
Yeah,
paper.
we are
Mm.
chattel paper. Okay.
But do y'all understand? Can you see how extensive that is? That's money you generated off your signature that they
That
use
belongs
and
to
they
you.
selling and trading it. Yeah. So y'all still okay with just doing the 1099, right? Okay. I
Or
certainly
y'all,
wouldn't be okay just
or
doing a
y'all just okay
1099.
with, right? Or just okay with getting your title. It's bigger than that.
This
It's
is
bigger,
what
but
we
what they
mean
did was,
when we say securities fraud.
so let me show you. All right. I'm gonna go down some more.
If you don't know about the Bloomberg terminal, look it up.
This is where all the securities are done. So I skipped down here for a reason. So these companies that you guys are looking for, do you see all of these? These are every company that they transfer the note to. See how many times they do it? So for you guys that's been with me for a minute, and I've showed you guys how one business will have several sub businesses up under them, correct? So look at here. So we got iPick Texas is the same company as iPick Media, but because they got two different IEINs number. So what iPick Texas did, they took it, securitized it, came up with a QSIP number, okay? So then they took that QSIP number and then they transferred the security again to iPick Media LLC. So now they got another QSIP number. Then they transferred it again to iPac Gold Class Entertainment, iPac Gold Class Holdings. This is why when you will see, like with Discover, you'll have Discover Corporation, then you'll have Discover Trust, but they're all still one company. So what this
Discover Holdings
report
Company,
shows is
Discover
when you guys,
Deposit.
there you go. And so what this form right here is showing that when you're asking them for information via GAP, and you're asking them for the accounting on the other side, do you now see why they refuse to give it to you? Because having a document like this means that they are going to fold with you quickly. Because do you know, if I was to take this piece of paper and I was to do a report through the security exchange about securities fraud and the comp controller, every last one of these companies are liable. Because what does the law say? Under 16 CFR, it says any holder of the consumer credit contract, the debtor can assert their rights. So technically, this client can sue every last company on here. And at this time, it was 1,320 times, there you go, that they sold it. Even one time they even gave it back to her and she didn't even realize it, but then they sold it out again. So when people get to telling you that they can get your QSIP report and all of that, yeah, they can get your QSIP number. But if they are not considered a certified mortgage securitization auditor, a Bloomberg specialist, you can't use it in court. If this particular company was still open and she went to court, she can call these people in as an expert witness. Okay. When I first started doing this a couple of years ago, and the first Bloomberg report that I was able to look at, they ended up making like $728 billion off of the account. And when the customer put in a claim with the company and they showed them that they had this, they settled out with her for $18 million. It made her sign an NDA, of course, but she settled out for 18 million because showing this and having this proof right here from the Bloomberg terminal, having the QSIP number, people end up in jail, bankers, they'll owe the IRS. So when you do the work and you are able to obtain something in this magnitude, it all works in your favor. And when you are properly on the private side of the bank, this QSIP number technically belongs to her. So if she was on the private side of the bank properly, she can take this QSIP number, take it to the bank, and then sell it to them, because that's what they're doing. And that's technically what we're supposed to be doing. The reason that I showed you guys this to show you that it's bigger than just a debt. Do you understand totality of how much these people have made off of us? And they got the nerve to say that we still owe them. But they're only saying that we owe them is because we signed a sheet of paper saying that we will pay them, even though it was false and misleading. So that's why I say don't go rescind no contracts. Make these people pay you. Okay.
Can you see why there would be a big push for recension, right? That you have to understand there's a lot of people who give you bad information because they don't want you to get to this point. They want you to settle out with the little wins that you can maybe get before they change up the system on you. But when you come with something like this, it's total knockout. Like the severity of this.
And then I wanted to show one more thing before I take this off and we get into the power. Okay, so for everybody that I said, go pull your UCC 11. And I told you that if there's no lien there, there's no case. This report by itself shows you that they filed it with the official records, the Register of Deeds office, on February the 5th. What does this say? No recorded assignment of mortgage. So yeah, they put it in the mortgage book, but they never attached the lien to it. So lawfully, they can never go after her. And this is with every document you've ever signed, car notes and all. So with a car note, they're going to send it. That's why they ask you, oh, we'll send your paper off to the DMV and you can come pick your plate up from us, because they're never going to record it as a UCC. And as long as you think that there's a lien on your physical title, that you feel like you owe them. But the law says under the UCC that if there is no perfected lien, and there are two components to a perfected lien. The first one is the promissory note. Okay, you got that. But they say in order for that promissory note to be considered a perfected lien, where they can legally come after the debtor, it has to be in the UCC system. And if it's not there, they can't charge. Okay. Stinker, I'll let you ask a question. Go ahead. Stinker Fair.
Am I unmute? Can you hear me?
Yes, I can
Hey,
hear
girl, I'm ascending vegan. How you doing? I
you.
appreciate
Hey,
the call. And I'm going to tell you this right now, what you just said. I didn't even expect this. My husband just bought a car. They sent him the paperwork. We got the title and it says, go turn this in
nope,
and tell us we're the lien holder. I told him, don't do it.
don't do it. Because guess what? If he don't do it, he can't. This is why I tell people, when you go to buy a car, FYI guys, when you go to buy a car, do not go to the dealership to get the financing. Go to your credit union or your bank. They are going to give you a check, okay? So when you go into the dealership, it is considered a cash deal. They are going to send you the title because it was a cash deal. The finance companies are depending on you, just like she said. Oh, send it to her, tell her we the lien holder, girl. No, you don't, because there's nothing that they can do. They have no security interest. They're not on the lien. They don't have a leg to stand on. If I was you, I wouldn't do it.
Thank you. No, we're not doing
and
that.
this is
I
also
listen
what
to
we
y'all.
mean when we say it's voluntary, because if you were to do that, that would have been by your own choice. Now they may have requested it, but if you don't do it, what is the legal recourse?
Nothing. And I'm gonna tell you what they're gonna do. What they're gonna end up doing is, when she doesn't send the title over for them to put a security on it, they're gonna turn that auto loan into a personal loan. Tell me when they do it, because they're going to do it. Once after so long you don't turn it in, you're going to still try to get their money, and then they're going to turn it into a personal loan. So even when it comes to when you actually get in the car, they ask you, let us give this to the DMV. You have the right to say no. No, I'll do it myself. And you definitely can do it yourself. Okay, that was a very good example. I appreciate that one.
Well, thank you. And I just want to say they did offer. They said, go register it and we'll pay you the taxes back. They keep sending them letters that they're going to give them money to do it.
Nope, don't do it. And if I was you, so is the car just in your husband's name or is it in yours too?
It's just, we haven't got anything registered. The loan is in his name. We just got the paperwork in the mail about 4 days ago, but I told him, let me get into this meeting.
And you got the title, right?
I got it right here in my hands.
So this is what you do. Have him transfer the title over to you. And now you go put the car in your name. We play the same games that they play. Because technically he could sell the car. It belongs to him. He has the title. So y'all know, holder in due course, whoever has the title is the one that owns it. Because it's the possession is 9/10 of the law. Because she never let them register. They did it as a cash deal. They are waiting for her to send the title. And I will not. If they make a mistake and send you your title and it's free and clear, don't send it back to them. Okay, they mess up. They take enough money from us. Because still at the end of the day, that contract that he signed, even though they don't have security interest, they're still selling that contract. They sell contracts for 33 years. Come on, y'all. Y'all know how they do their numbers. Everything is in threes. They're all Mason's numbers. Just like your birth certificate, it was sold for 33 years. Each one of these contracts are sold for 33 years. Because this contract that I just showed you guys started in 2013. They are still going to transfer this contract all the way to 2053. And I'm going to show y'all because it's on. Where is that? Does it say how long? Oh, it's down here. How long they're going to trade this title. And so now do you guys see that was in my arbitration class? Why, one, they say that there is no statute of limitations on fraud. Get that 3-year THIER stuff out your head, okay? There's no statute of limitations on fraud. This is considered fraud, okay? Y'all have heard us talk about Regulation X. Y'all heard us talk about Regulation Z. They putting it in your face, okay? But let me show y'all where they're going to sell this contract up until 2053 is on one of these papers. So while I'm looking for that, the good thing about it, y'all know Path to Freedom always got to make sure that anybody that come across my path is available. Path to Freedom / Henry Ross and Consulting now have a financial auditor that is on the team, that a financial forensic auditor. So for every one of you guys, if you're on here and you're my arbitration clients, please understand that every last one of you will get one of these reports. Here we go. Maturity date, 1/16/2053. And they started it in 2013. They still making money off of it, unless we do something about it. And even if they pay her out, unless she requests for them to stop selling this security, they're still going to do it. If it was me personally, I'll take possession of this QSUP number and then I will go into a security transfer agent and go and resell it to them. Can't sell it to Wells Fargo because they're the one that started it. Okay. So that's just to show you guys that this is a lot bigger than what you think that it is. It is a lot bigger than, oh, just let me get my title and my deed. Do you understand? That should be very upsetting. The very first time I ever seen one of these reports, I was pissed. I was pissed because they are making billions and millions of dollars off of us, and it's not fair. Okay. All right, nephew. So we're going to get into the UCC. The United States, the USCs, okay, everybody is always hollering the USC. But let me ask you something. If in one breath you're saying you're not a US citizen, why are you trying to use US citizen rules? The United States Code is for United States citizens, right? So how are you trying to say in one moment, I'm not a United States citizen, but then you go in there throwing 1681 and 1692 at these people? It doesn't work that way. You have to also understand that the government and the banks are two separate entities. They have two separate meanings of terms. Their policies and procedures are different. That's why when you're going through this process, you have to do it on every level. Those who did the steps in the recording national status and the do not detain, all you did was stop being a government slave where they can't tell you that you got to get a shot or the other things, right? That they say you have to pay taxes. But so you got that part fixed. But the main corporate, as y'all see, is the banks. The banks run the world. I've said it before. There is a banker's constitution that we are under. You might want to go pull it. The banks run the world. This new Fed now system, don't let them hype y'all up with, oh, I can get my money the same day. I ain't got to wait till Friday. It's a setup. It's a setup for the new system. Don't y'all fall for the, oh, I can pay $11 and now I have a blue check on Instagram. The reason that they're doing that is because in order for you to get a blue check, you have to send in your identification so they'll know who you are. And the new system that they're going to put up with those 4 classes of people of the post that I put up the other day, they can go on your post and say, Siobhan Tingle, 4 months ago, you said a post that we didn't like, and you try to use your debit card and it's cut off. Because that's what they're going to be able to do with the Fed now system. They're going to have a point system. If you use too much carbon, and it's ridiculous on how they're about to try to control the people. So don't fall for the, oh, I'll be able to get paid right then. They never are giving us something for nothing, and you'll be giving up your freedoms. Make your own social media, because in a minute, everybody gonna have to have a blue check. Everybody's gonna have to verify. And at that day, I will not be on social media at all. You're not getting my ID. You're not gonna go back on me 5 years ago and say that I said something that you didn't like, and then now you about to cut my money off. It don't work like that. Okay. So, nephew, you good? Go ahead.
And I mean, if that doesn't, get you motivated and make you want to pursue remedy harder than ever, I don't know what will. Like, you literally just saw how they turned a $200,000 mortgage into $518 million. And this is happening with every single thing. They are selling your credit cards. They are selling your car notes. They are selling your phone bills. And they are making all types of money. If you have been with your phone company for years, imagine how much money they made off of you. And that's your signature on it. And you're entitled to it. But guess what? You're a minor. So your custodians are keeping it nice and safe. I don't know about you, but that doesn't fly with me. But now that you understand what securities fraud is, I'm going to take you to the laws that govern the securities, right? Because you see all the UCC codes going around, but now you're actually going to be able to understand what these codes are, right? Especially like UCC 1-308. How many of y'all actually know what that means? Raise your hand if you understand the full purpose of UCC 1-308 versus just, I know I'm supposed to reserve my rights. What is the meaning of that? Just raise your hand if you know. Nine people. See, this is what I mean. This is what 13 hands going up. Still, compared to the amount of people in this class, the number of hands that I'm seeing is far too low. But it's okay. So, UCC 1-308, a party that with explicit reservation of rights promises or performance or assent to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved, such as words without prejudice or under protest are sufficient, right? So basically, I'll get to what that means in a second, but can you go to UCC 1-103? Now I can see it on my screen, so I know you all should be able to see it on your screen. And if you can't, scroll over. So, construction of the Uniform Commercial Code. It says, the Uniform Commercial Code must be liberally construed and applied to promote its underlying purposes and policies, which are to simplify, clarify, and modernize the law governing commercial transactions to permit the continued expansion of commercial practices through custom usage agreements of the parties to make uniform the law in various jurisdictions. The most important part of this is subsection B, though. Unless displaced by the particular provisions of the Uniform Commercial Code, which means unless the Uniform Commercial Code is adding more protections, not taking anything away, the principles of law and equity, the law merchant, and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause supplement its provisions. That means that the principles of law and equity The law of merchant is exactly what it sounds like, the law of dealing with merchants. The law relative of capacity to contract. You have to be in a capacity to contract, otherwise it doesn't work. Principal and agent. What are the principal? What is the agent? Estoppel, fraud, misrepresentation. So all of the things that are unlawful according to common law and the rules that have been agreed upon by most people, it's how do you say, it's common sense. It is automatically assumed to be that it is known. You see what I'm saying? So these are the principles on which this law is formed, and those sound like pretty good principles. Those are pretty black and white. It doesn't sound like it's too keen on fraud or misrepresentation. And we just showed you how where in any of your documents do they tell you that they're going to sell that security and make millions of dollars off of it? It's all misrepresentation. You could even argue duress or coercion because you are under duress. You don't know what's going on. They're pressuring you to sign things. There's so many things going on. So that is the construction of it. That is the basis. That is the soul of the Uniform Commercial Code. That is its backbone. And it doesn't bend very easily on those things. Now, understand this, and this is what you'll find in every single one of your contracts. Can you go to UCC 1-105? And you guys should be writing these down, taking notes, and when we're finished with the class, go through and read the entire Uniform Commercial Code, not just the aspects we're going to cover in this intro class. Now, if any provision or clause of the Uniform Commercial Code or its application to any person or circumstance is held invalid, the invalidity does not affect the other portions or applications of the Uniform Commercial Code, which can be given effect without the invalid provision or application. So basically, and you'll even see this in your contracts, it's a severability clause, basically saying if one part of this contract is found to be unenforceable, then the other parts of the contract remain. So a good example of this is when they are reporting your information to third parties, right? Because they'll say in the contract, we may report your information to third party. That may is with your assumed consent. So if you ever revoke your consent for them to do so, then that becomes an unconscionable clause. So it is not severable. So it cannot be held, right? If you went to court, you would be like, well, this cannot be held according to the Uniform Commercial Code. It's held invalid, but it doesn't invalidate the entire agreement. So that's one other thing to keep in mind. So that is what it is. So next, can you go to 1-201? So when you are reading any law, anything like this, start with the definitions. Start with the definitions, because all of these words are what you're going to see throughout this entire article of the Uniform Commercial Code, specifically part 1. So it's going to be a different set of definitions for each part. It is important. Now, some definitions are uniform throughout, but others are unique to their section. So be mindful of that. So unless the context otherwise requires, words or phrases defined in this section or in the additional definitions contained in other articles of the Uniform Commercial Code that apply to the particular articles or parts thereof have the meaning stated. So unless they state otherwise, the meanings are the same. So these are the general definitions. So you're gonna see here what applies to you. What is an action in terms of the Uniform Commercial Code, right? When we say that they're speaking a different language, which is legalese, this is the different language, because you know what an action is in your general sense, but what is an action according to the Uniform Commercial Code? According to the general definitions for the entire Uniform Commercial Code, in the sense of a judicial proceeding, it includes recoupment, counterclaim, set off, suit in equity, which is arbitration, and any other proceeding in which rights are determined. So you going into arbitration is an action. You are the aggrieved party. That is the party who is entitled to pursue a remedy. Okay? Now look at this agreement as distinguished from contract. So an agreement and a contract are two separate things according to this code. It means the bargain of the parties, in fact, as found in their language, or this is the important part, or inferred from other circumstances, including course of performance, which it goes over performance, course of dealing, usage or trade as provided in section 1-303. And so what you would do is you would go look at the definition of usage of trade as provided in section 1303. Do that on your own time, but that's an example of where if it references another code, stop right there go to the other code that it's referencing, understand what that means. So that way, when you're moving on, there's no gap in your knowledge. So a bank means a person engaged in the business of banking, including a savings bank and a loan association, credit union, and trust company. So this is important here. Bearer, right, means a person in possession of a negotiable instrument, document of title, or certificated security that is payable to bearer or endorsed in blank. So when you get these securities, you are the bearer. You're in possession of a negotiable instrument, or if you're in possession of a document of title, right? Now, bill of lading means a document evidencing the receipt of goods or shipment issued by a person in the gates of transporting or forwarding goods, and that has more to do with the shipping and delivery. Branch includes a separately incorporated foreign branch of a bank. Why would it say a separately incorporated foreign branch of a bank? Can anybody tell me why that might be? And I'm going to start with who's the first hand up? Misha? Why would they, do you have any reason why they might say that a branch would include a separately incorporated foreign branch bank? Okay, maybe not. Moving on to the next person.
So
Kosh,
I want you
go
guys to
ahead.
think. I want you guys to think about what he's asking you. Okay. So I just showed you how one business has 5 other businesses up under them, but then they have the parent company. So for example, you have the regular Wells Fargo Bank, but then you got Wells Fargo Securities. Maybe that'll kind of help y'all understand it, right? But you can go ahead and choose your next person.
And if you have your hand up, please be ready to answer questions. So we're going to lower this hand. Kasha Johnson, let's try you.
Here.
Hey,
What name is that?
Tasha.
Okay, perfect.
I didn't have a question on the UCC just yet. I was going to wait till the end and ask questions at the end.
Oh, okay. I see. I see who's unmuted. Okay, that's fine. We'll do.
Hello. This is
Kasha?
Kasha.
Yes. Okay. Do you have an answer to the question?
You were talking about the branch, right? Or
Yes.
can you repeat?
Why would it say that a branch includes a separately incorporated foreign branch of a bank? Why would that be the case?
I believe that is because the banks can be, as described above, a savings bank, a loan association, a credit union, and a trust company. And we know that, for example, if you get a car, they are considered a bank, and they work under the construct of a trust company, which can be considered a foreign branch of that corporation. That's just a guess, but.
And that would be a correct guess. That's pretty much it, because they are all operating under separate branches, and depending on where they're registered, if it's the same business registered in different places with different EINs and all those things, they are considered foreign to each other. So that's exactly the point that I was trying to make. Thank you very much.
Can I ask later?
And then that also goes back to the fact that when you guys begin to look up these companies, for the most part, they're all registered in Delaware. That is where their principal registration is on a state level. There's a couple of reasons why it's in Delaware. One, Delaware is a private state. You'll never know who owns it. All you're going to see is their registered agent. Number two, that's where the chancery court is, because we're dealing with equity. Okay. So that is where the chancery court is located. And number three, they always register in one state, so that, let's say they registered in Delaware, but their principal office is in California. California is now considered foreign. So at the beginning of this call, I told you guys that the rules to the security exchange is that foreign companies are not obligated to report each one of their securities. Okay. Not unless one of us do a whistleblower on them and then they get audited. But they don't have to report them. And this is why they're getting away with the security fraud and the tax fraud, because they are not obligated to report because they are considered a foreign company, and foreign companies cannot be touched, which is one of the main reasons I tell everybody, get you a foreign trust and put your entire life inside of that trust, because now you can't be touched if you're inside of the trust.
Can I ask a question later about this?
You can, what kind of question?
Possibly.
I mean, you could probably ask it now.
Yeah, this would be the most appropriate time.
Okay, so with regard to this, I'm actually I am gonna sign up for you guys to help me out, but I was looking for your link for one-on-one. I guess all I can do is the arbitration link because I didn't see a one-on-one anymore. So I'll do that tonight. But I'm in arbitration with Exeter right now. And I wanted to know if I should move it to I found that their lawyer is also representing the dealer, because I added the dealer to my arbitration. And he's like rubbing it in my face that I can't go to federal court because of the contract I signed. But I told him the contract was in fraud. It's a whole fraudulent contract. The finance fee, everything is wrong within the contract. So it was constructed with false premises. So it's a null and void document. And I want to move to federal jurisdiction.
Okay, so if you do have an arbitration clause in there, they're going to just do a motion to vacate it into arbitration because that's the proper venue, and they will hold that, and it has been held in many high cases.
I found some case law that would help me out with that.
The rule of case law is that you'll always be able to find some supporting your point, but if it has an arbitration clause, that what I'm trying to say is that that's just going to be the more proper venue to do it rather than in federal court anyways, and it's not going to get to federal court.
Well,
like I said, I'm sure you have.
I
understand.
Oh, okay.
I understand. I know you have. I know you have some case law, but like I said, it's been held in the Supreme Court that if there is an arbitration clause, it must be enforced, and that is the general common law doctrine that they say today, right?
Okay.
But
well, I'll just sign up for
arbitration
your
would be-
class, and
Yes.
I mean, I'll just sign up for a one-on-one with you if you have something coming up soon, hopefully.
Yeah, so that'll be the most efficient way.
I don't want to take up
to
your
do
time,
that.
so I appreciate you guys. Thank you.
So
Of course.
I kind of missed that. So she in arbitration court and what happened?
She's in arbitration court, and I think she was trying to do it in federal court, but they were like, no, you're not doing it in federal court because the contract you signed has an arbitration clause. So I was just trying to explain that generally it's been held in the Supreme Court that if you have an arbitration clause, it's going to be enforced any disputes in arbitration. And so
Absolutely.
she tried to go straight to federal court, and I was just like, you can't do that.
You can't do that. Just the same way, but see that goes both ways though. And I tell you guys, the first thing to do is to read your contract. It says it on the contract that if you have any legal issues with them, you have to take to arbitration. If you didn't want to do it in arbitrary means, you had 30 days from the day that you signed that contract to rescind the arbitration contract, right? But see, it goes both ways. The clause said that any legal action on their side and yours, they have to take to arbitration. So if you ever got your car repoed, you know you can use that law to get your car back because they didn't take you to arbitration when their document says it. And then federal court is not the proper venue for it. You are looking at law and equity. The federal court is not a regular courthouse. It is tax court on a tax level, on a federal level because of the amount. This is why people taking consumer cases to federal court and you're losing, or they're doing what she just said they did. They're going to file a paper asking for it to be dismissed due to a mandatory arbitration agreement. But so guess what? Say you in court right now being sued by a credit card company. All credit card companies have arbitration clauses. Do the same thing they did. Ask for it to be dismissed due to mandatory arbitration clause. Almost every lease with a corporate company, residential lease, has an arbitration clause in there. So if they take you to eviction court, all you have to do is put in a motion to remove, if you already got a judgment, motion to vacate judgment due to mandatory arbitration clause. So, and then when y'all take these people to arbitration, I hope y'all ain't in there talking about USCs and this contract fraud because you signed it, you said you understood it. You have to go at them with securities fraud. I'm gonna say it a million times. It's securities fraud. I've showed you guys it's securities fraud. But if you try arbitration, if the stuff that you're hearing all over social media, rescission of a contract, and this, that, you're gonna lose. The sad part about it is that arbitration is binding. The only other recourse you'll have will be to do a complaint with the security exchange. But if you couldn't get past arbitration, the security exchange is going to look at your report and be like, you still don't know what you're talking about. You know what I'm saying? This is why we tell you guys to gain the foundation in which it is that you need. And I will say this a million times too. I get at least 10 consultations in a week. And everybody talk about I stopped paying my bills. Why? If you don't have it put in proper standing and you stop paying that light bill, I'll send you a candle because you're going to need it. Yes, we know that they getting us. I just showed y'all how they getting us. But you guys have to play the game properly. Learn your position, learn it well, and move the chess pieces properly. Or y'all gonna keep getting repo, y'all gonna keep getting foreclosed on, y'all ain't got no lights, no gas, no water, and don't come to me and Caleb talking about they cut it off because we never told you guys not to pay your bills until you had it in a do not pay, do not collect status. Okay.
And
Go ahead.
I understand, like, for the person who recently came, like, I understand wanting to go into arbitration as soon as possible, but did you have a full I don't believe that you had a full defense prepared or that you were quite ready to do that. So then, like you said, you're going to come and book with us, which is no issue, but it does make it a little bit harder if you're already, but not so much harder because it's really open and shut, and we'll keep going. But it's just, there's a proper order, and I personally would not be attempting things without even further study. And especially jumping into something like arbitration, which is a legal binding proceeding that if I mess up, there's no second chance. So that's all I would say is be wary of that.
Yeah, and
I understand wanting to get your stuff, but you've been paying it this whole time. Sorry, Auntie, real quick. You've been paying it this whole time, and no matter when you finish paying it, you're going to get the same amount of money back. So whether you stop paying now or later, I understand it wants to be now, but that's the only point I'm trying to make here.
And then the thing about it too is you have to read your contract because some contracts say that you have to do pre-arbitration first, which means you have to contact them first and tell them that this is what you're seeking, this is what they did. And then if they don't respond back in a certain amount of days, then you can take it to full arbitration. But even with arbitration, yes, the contract does say contact the AAA, right? Or JARS. But if you are dealing with the security that is held with a corporation that is on the stock exchange, then that's a totally different way of doing it. Then some of you guys are filing arbitration and you're doing it as document only. That's not how that goes. You're going to lose. So I have a few people that I have to tell them to rescind your case so you won't lose it. And then we got to start it over because it wasn't filed properly. That's more time that's taken away from you being able to get the remedy that it is that you seek. So y'all just be careful on what you guys doing. Make sure you have the proper foundation to do it, which is ultimately why we're doing these things. And every last company that you're dealing with is on the stock exchange. That means that your arbitration needs to run under the FINRA rules, which is a totally separate rules, which means you're supposed to have 2 to 3 arbitrators that's supposed to be on the case. It's supposed to be ran totally different. So that's why people are clogging up the arbitration system with billing errors and this, that, and the other, and you're going to make it harder on yourself. And I'm just being honest with you, just honest. So I just wanted to say that. But go ahead.
Thank you. Going forward, please keep your hands down until I ask a question, because I understand some of you want to ask questions at the end. But if you put your hand up, I'm going to get confused because I'm going to choose you and then you're going to say, I don't have a question till the end. So please only raise your hand when we ask you to raise your hand and answer the question that we ask only, so we can keep on topic, because otherwise in the replay, other people will get confused because we're going on to different subjects, right? So I just want to keep it on topic as much as possible. Again, please don't raise your hand until we ask you a question, and only if you have intention of answering that question and that question only. Now, continuing on with the definition, the burden of establishing means a fact, means the burden of persuading of the trier of the fact that the existence of the fact is more probable than its non-existence. The burden of establishing belongs on you when you are going into arbitration or any consumer remedy or administrative process that you're trying to administer. The burden of establishing proof is on you, which means that you have to persuade someone that what you're saying, that the fact of it is more probable than non-probable. So when you pull up a Bloomberg terminal certified, financial forensic audit report showing how much money they made trading the security and the fraud, that is an overwhelming burden of proof established that you have done there. So the buyer in ordinary course of business, this is everyone in their common sense, means a person that buys goods in good faith, right? And then good faith tells you, we'll go back over it again, but it tells you that honesty, in fact, in the observance of a reasonable commercial standard of fair dealing. So that's what it means, buying in good faith. You went to the dealer, to anywhere you're going to get stuff, in good faith, without the knowledge that the sale violates the rights of another person in the goods and in the ordinary course from a person other than the pawnbroker, et cetera, et cetera. So a person that buys goods in the ordinary course, if the sale person comports with the usual customary practices in the kind of business in which the seller engaged, or with the seller's own usual or customary practices, a person that sells oil, gas, whatever, et cetera, et cetera. Basically, you are buying it and you have a right to recover goods under Article 2 and all of these things. So sales is a whole other article in itself, and that's going to be the very next one. So conspicuous, with reference to a term, means written so displayed or presented that a reasonable person against which it is operate to ought have noticed it. Whether a term is conspicuous or not is a decision for the court. Conspicuous terms include the following heading in capitals, greater than size and surrounding text, and contrasting type or font, etc. So when you see your truth in lending disclosures, those are meant to be conspicuous, right? They show you the finance charge, they show you all of these things, and they give you all of those things. So that's why the heading is written like that. This is breaking down why your contracts look the way they look, what they're supposed to contain, all of this. So consumer means an individual who enters into a transaction primarily for personal, family, or household purposes. This is
Let
important.
me interrupt you for 1 second. So because he brought up consumer, if anybody has a car note paper near you, if you look at the top, it should be on the second area, the last box on the left-hand side. There's going to be a box that says, check if it is not for personal, family, or household purposes. So when you guys are going after these people, use their own agreement against them, because the box is never checked. If the box is checked, it'll be checked for business or commercial. Due to the fact that the box is not checked, they have just told you that this transaction was done as a personal, family, and household purposes, where now these UCCs that you guys are learning, you'll be able to use these as your defense, because the application already told you that it is for personal, family, household purposes, and that you are actually the consumer. Okay, go ahead, nephew.
No, that's perfect. So then contract, as distinguished from agreement, means the total legal obligation that results from the party. The agreement is determined by the Uniform Commercial Code as supplemented by other applicable laws. So you have an agreement, it doesn't become a contract until you sign it and both parties agree, right? But again, these companies have no, capacity to contract because they're legal fiction, but that's another thing. Anyways, creditor. So again, according to the Uniform Commercial Code, this is what a creditor is: a general creditor, a secured creditor. Again, secured party, secured creditor, never secured party creditor. A lien creditor, and any representative of creditors, including an assignee for the benefits of a creditor, a trustee in bankruptcy, a receiver in equity, an executor or administrator of an insolvent debtor's assigner's or assigner's estate. That's a very broad definition. And if you know what's going on about these terms should be familiar to you, executor and administrator, all of these terms, because this is all trust law, right? Trust law is a very important aspect of law to study when understanding these things. So a defendant includes a person in a position of the defendant in a counterclaim, cross-claim, or third-party claim. And I know it might seem crazy, I'm going over all of these definitions, but it's important that you understand what all of these things mean, because all of these same words are going to keep popping up with what I'm showing later on. But I do have to speed it up, otherwise we will be here all night. Delivery with respect to an instrument, document of title, or shadow paper. Remember, if you heard that term earlier, shadow paper, we are the shadow paper, means voluntary transfer of possession. So you delivering your instrument to them is you transferring the possession, and they go over how to transfer the possession. Document of title includes a bill of lading.
Hold on, before you go to that part. It tells you right here, this statement is so important. You know, you shadow paper or the document of title, y'all just heard her say earlier, they're asking for the title. They want her to voluntarily transfer them possession. You guys got more power than what you know that you have. And as long as she does not voluntarily transfer it, it is nothing they can do. So the reason they want her to voluntarily transfer the possession of the documented title, so they can now become the lien creditor. That's it, that's all.
Y'all see how that works? And again, that's why I highlighted that voluntary transfer of possession. So it doesn't matter what you're delivering, whether it be an instrument, title, or chattel paper, you're transferring possession to someone else, making them the holder in due course of the instrument who is entitled to enforce, et cetera, et cetera. So do you see how it all links together? And this is why the Uniform Commercial Code is one of the most important things, because it is the basis of all contracts. And if you understand the basis of all contracts, you cannot lose. So again, moving on, we know what a documented title is. Fault means a default, breach, wrongful act, or omission. So if they omit the information from you of what they're really doing and what the true purposes of this agreement, would that not mean that they are at fault? I do believe that it would. Genuine means free of forgery or counterfeiting. Holder, a person in possession of a negotiable instrument that is payable either to the bearer, which remember, you are the bearer, or to an identified person that is the person in possession. B, the person in possession of the documented title if the goods are deliverable either to the bearer or to the order of the person in possession. So when you pay something to the order of who you're sending it to, this is why they become a holder of the instrument. And once they become a holder of the instrument, there is certain duties that they have to that instrument, and we're going to go over those. So insolvency proceeding, including an assignment of the benefit of creditors or other proceeding intended to liquidate or rehabilitate the estate of a person in resolve. So if you've heard that term before, insolvent means having generally ceased to pay debts in the ordinary course of business, other than as a result of a bona fide dispute. Being unable to pay debts as they become overdue, or being insolvent within the meaning of federal bankruptcy law. So this is what money is. Whenever somebody is saying that you have to pay in money, all money is a medium of exchange currently authorized or adopted by a domestic or foreign government. The term includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more countries. That's it. The medium of exchange currently authorized. There is many different.
And that's the only reason, the meaning of money. So the FRNs that you guys like to refer to them as is not money, it's actually a debt note, right? And when you get deeper into each state's UCC, you'll see that it says that a state cannot say that one certain species can be used as currency. For example, there was a court case a long time ago. In court, they ruled against the guy. They told him he had to pay a certain amount to the creditor, okay? They never said what he was supposed to give, because the state cannot tell you that you only can use one form of payment, okay? So he went and got, and I'll find this case, it is very old. He went and got beans, pinto beans, the ones that be in our pots on Sunday, and counted out that amount of pinto beans and the amount of what they said he owed, took it to the court and gave it to them. And when he went back in front of the judge, he said, well, you didn't say that I had to pay it in a certain type of way. He used the UCC law because the UCC law is on a federal and a state level. So each one of your states have one. And plus you have the federal one to back you up. They had to discharge his case off because we don't have any money. Because according to Congress, money is silver, gold, and minerals. Well, the bean is a mineral because it came from the ground. So it's the UCC. What our point of doing this evening is for you guys to understand that get those USCs out of your head. Use them for credit reports and other things. But when it comes to these debts, everything is ran off of the Uniform Commercial Law, period. Everything. And so when you begin to learn these and you understand the meanings of their terms and what it means for you, you guys will stop getting your letters ignored. As soon as they see a 15 USC, you can't even use that. That's illegal because you're not a US citizen when it comes to securities. Okay. Oh, that's that.
Hey, I hope y'all are really listening and taking good notes on that. Now, purchase means taking by sale, lease, discount, negotiation, mortgage, pledge, lien, security interest, issue or reissue, gift, or any other voluntary transaction creating an interest in property. Record means information that is inscribed on a tangible medium or that is stored in an electronic or other medium and is retrievable in perceivable form. Calling somebody up on the phone is not having a record. Walking in and talking to them face to face is not having a record because that is not tangible. The words that you say, that's hearsay. This is why we say to do everything in writing. It has to be in a tangible form, stored in some medium that is retrievable and perceivable. You have to be able to pull it up at any time. This is why everything must be done in black and white. That's it. Representative means a person empowered to act for another, including an agent, an officer, a corporation of association, and a trustee, executor, or administrator of an estate. Security interest means the interest in personal property or fixtures which secures payment or performance of an obligation. So hold on. If security interest is what secures payment or performance for an obligation, why would you give security interest to the company? Why would you do that? It doesn't make any sense for anybody to do that. Because that is what's securing the performance. You're saying, yeah, I'm going to give you the security interest securing my obligation, taking on an obligation that don't belong to you in order to perform and pay, right? So it's total madness.
And then you see, once again, it says other voluntary transactions. And this is why we keep telling you everything that they're doing, you voluntarily either signed it or you acquiescence to it. But as you see, everything is done voluntarily. So just like you can sign something, you can take your signature away. And I don't mean by rescinding a contract. Due to the fact that your name is the only one on that contract, and when it gets to talking about security interest, there's a part in there that says, you give us the right to transfer. Now, I just showed you guys how many times they transferred that note. You told them they had the right to transfer. You could have changed that. You could have changed that and scratched it out and say, no, I don't want you to transfer it. Or you only are able to transfer it 1 or 2 times. You see what I'm saying? So unfortunately, everything they're doing is based on a voluntary system, just like taxes are. Now you are going to learn how to go back, still be able to get credit for what you gave security interest in, but now you control it by voluntarily only giving them so much. And it's a reason why they keep using this word throughout this entire UCC. It's telling you that everything is voluntary. Okay.
And again, notice how it says all the time when referring to you, the person who is engaging in this contract in good faith, and that the person who is doing it is doing it according to the customs and the way that it's supposed to be done. So our mistake is assuming that these people are doing things how they're supposed to, are doing things the right way. And when you learn that they're not, and you understand why they're not, it's much easier for you to fix it. So then state means a state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, or any other territory or insular possession subject to the jurisdiction of the United States. Now, notice how the 50 states of the Union were not mentioned in there at all. See, in other codes, it will be very specific when it says that state means one of the 50 states of the Union. If a state means a state of the United States, that is the District of Columbia, and notice how it only names federal territories there. So surety includes a guarantor and other secondary obligor, and that's pretty much the main things that you need to know.
Before you stop that, I want you to go back up. They tell you that you can get your remedy.
Oh yes, remedy. I forgot to go over remedy.
32. They're telling you means any remedial right to which the aggravated party. What do they say aggravated party is? That's you. Means a party entitled to pursue remedy. That is why on every last one of your contracts, you will see 16 CFR 433.1, where it tells you that any holder of this consumer credit contract, the debtor, which is you, can assert their rights. So your rights that you guys are trying to assert needs to come from the UCCs. If the bank around the world, the UCC is based on monetary actions, okay? For you guys that's in Florida, I know y'all seen it, but if you guys haven't, go and pull the press conference that the governor of Florida did when they started talking about the FedNow system, okay? So he was saying that Florida is not going to be a part of it. Texas, we sure ain't about to be a part of it. But what stuck out to me during his whole news conference is this. He said, I would encourage every state to include in their uniform commercial code that they refuse to do the FedNow system. Texas is writing within their UCC code for Texas to have its own gold-backed currency. For every dollar we give to Texas, they're going to give us gold in exchange. This is how strong this UCC is. It's the UCCs is what we should have been looking at instead of the United States Code. They got us so bent on the United States Code that we overlooked the Uniform Commercial Code, and this is what runs everything. So this is the Uniform Commercial Code on the federal level. And you have one individually for every single state has its own UCC code too that have some additional protections in there that the federal one doesn't have. That's why when you're going after these companies, you can use federal laws and you can use your state laws in order to get the remedy as they showed you that you are able to get. So that just stuck out. Like, you have that right. You are the aggravated party. You entitled with or without resort to a tribunal. Do y'all know what the tribunal is? That's real court. That's Article 3 court. That's Chancery court. Everything is ran, all the land is tribal land anyway, if you didn't know that. For example, the Department of Urban and Housing Development. That's not the full name of it. The full name is the Department of Urban and Housing Development, Indian Affairs, because everything is tribal. Use their own words against them. They said you can go get your remedy. Do you see any of them talking about any remedy using the word remedy in the USCs? No, because the USCs is not what you're supposed to be writing in those affidavits or whatever you guys are sending. If you're not going to go the route that the contract says, you'll have a better chance with them if you're able to understand that they are all running up under the UCC. Okay, nephew.
Exactly. It is literally the underlying principles are law and equity. That's all you need to know. Contract. So then can you go to UCC 1202? Very next code. So
You
again,
said 202?
mhm,
Okay.
that's yeah. So notice of a fact, if the person has actual knowledge of it, has received a notice or notification of it from all the facts and circumstances known to the person at the time in question, has reason to know that it exists. So a person notifies or gives notice or notification to another person by taking such steps as it may be reasonably required to inform the ordinary person, the other person in ordinary course, whether or not the person actually comes to know of it. A person receives notice of a notification when it comes to that person's attention. It is duly delivered in a form reasonable under the circumstances at the place of business which the contract was made, or at another location held out by that person, and is the place for such receipts of communications. So that when you are sending someone a notice, you can only claim that they have knowledge of it if you send it to the place where they normally receive those correspondences, and it is duly delivered in a form that is reasonable, right? This is why we say to go registered mail, because then you have a tracking number, and then it's very a secured service, and you can see exactly when it was picked up and the person who signed for it. So this is why it's proper for you to send it registered. And there's other reasons behind that, but the main reason is that you are giving notice and knowledge. And then last thing we're going to cover in Article 1 is UCC 1 305, right? I would again go through and look through all of the rest of this, but the remedies provided by the Uniform Commercial Code must be liberally administered to the end that the aggrieved party may be put in as good of a position as if the other party had fully performed, but neither consequential or special damages nor penal damages may be had except specifically provided in the Uniform Commercial Code or by other rule of law. A right or obligation declared by the Uniform Commercial Code is enforceable by action. So remember what action is. Declaring it specifies the different and limited effect. So these are the basic underlying principles and everything that you need to understand, right? So can you go over to, we're going to jump to Article 3 now, but I strongly suggest you read Article 2. It's just for the purposes of saving time, I want to go over some specific sections. Once again, can you go to 3103 definitions? So a drawee means a person ordered into a draft to make a payment, which is you. You would be the drawee. A drawer means the person who signs or is identified in draft as a person ordering payment. Oh, wait, never mind. I think I got that confused. Yeah, go ahead.
I want you to go back up to this one. Consumer account.
Oh, yes.
Means an account established by an individual primary, here we go, personal, family, or household purposes. So I'll give you guys an example. Wells Fargo. I deal with them a lot, so I use them a lot. So if you go online to wellsfargo.com and try to open up an account, it's just going to have a regular application on there. You have done it online like you are a computer. When you're actually supposed to go inside of Wells Fargo and tell them to give you the paper application for a consumer checking account. This is how they know the difference that you are a live person, because it's primarily for personal, family, and household purposes. Now, the application does look almost the same. The only difference is at the top, it says consumer checking and savings application. That word consumer, once again, puts the liability on them, because that shows that you're using it for personal, family, and household purposes. And even though the original application that you filled out did not say consumer, when they actually transfer that information over through their systems, they have you in there as a consumer, but they have you in there as a minor so that they can retain custodianship over the particular account. Okay, I'm done, nephew.
Okay, so order means a written instruction to pay money signed by the person giving the instruction. So when you are endorsing your coupons and anything like that, anything that you're endorsing, that's your instruction to pay money to whoever you're giving it to, right? So then I want you to take a look here at number 15, which is remitter. Again, the entire definitions are important, but I'm only focusing on a few things here. The person who purchases an instrument from its issuer if the instrument is payable to an identified person other than the purchaser. So when you're hearing remittance and remittance payments, it is in connection with something like this. The instrument is from its issuer is payable to an identified person other than the purchaser, and it's because they're always transferring the note, if that
And
makes sense.
just think about what I just showed you guys on the audit report, right? How they kept taking it to somebody else and somebody else and somebody else. That's what they did. They purchased the instrument from its issuer. So on that particular one, the issuer was Wells Fargo. Yes, they transferred it, but only the security transfer agents can turn it into a security by transferring it to the treasury. So that is when you look at the word remitter, just think about that security form that I just showed you guys, right? And it's other than the purchaser. That's also why I said that if she was to take control of that QSIP number, she couldn't go back to Wells Fargo to turn it in because they are the ones that started the note. But she can sell it to anybody else besides that, even though Wells Fargo will still get residuals because they are the originator, okay?
They are the original purchaser. And on that exact note, can you go to the very next one, 3104, right? So we say that they are the original purchaser. Well, what did they purchase, right? We all know that they purchased your contract. So what exactly about your contract makes it so special, right? So let's look at the definition of a negotiable instrument, which again falls under that definition of a medium exchange. All it is an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise order if. So these are the three things that constitute a negotiable instrument. It is payable to a bearer or to the order at the time it is issued or first comes into the possession of a holder, is payable on demand or at a definite time, and does not state any other undertaking or instruction by the person promising to pay or ordering payment to do any act in addition to the payment of money, but the promise order may contain an undertaking of power to give and maintain or protect collateral to secure payment, right? Because there has to be equal consideration in a contract. Authorization of power for the holder to confess judgment and realize or disposal of collateral, waiver of a benefit of the law intended for a waiver of the benefit of any law intended for the advantage of the protection of an obligor. So you can waive your own rights, basically. But your contracts, they are payable to the bearer at the time it comes into your possession as a holder. They are payable on demand at a definite time, and they do not state any other undertaking or instruction besides you promising to pay. So by that very definition, the contract that you initially signed is a negotiable instrument. That's what they purchased. That is the security that they're trading. Everything else that they're sending you is the proceeds, the interest, if I'm not mistaken. But
it is. It's the interest, and then every month, every 4 weeks, when you get that statement in the mail,
and it
that is
matures.
also another security, right? Which is why we told you guys about the stamp. If y'all remember what the stamp said, it was an order for them to deposit to get other securities from it. Which is why if you
go ahead.
Go ahead. No, you good. Go ahead.
No, I was going to say, and it fits those same exact definitions. It's payable to the bearer at the time it's issued, on demand or at a definite time, right? Because they definitely put a date. This is when it's due by, and it doesn't state any other undertaking or instruction besides you ordering the payment. So what you do when you endorse that is you're creating an order. So it tells you an order meets all the requirements of subsection A if it falls within the definition of a check. So a promise or order is not a check or an instrument. If at the time it comes into the possession, it contains a conspicuous statement, however expressed, to the effect that the promise order is not a negotiable instrument governed by this article. So unless it says on there, this is not a negotiable instrument as governed by Article 3, 104 of the Uniform Commercial Code, that means you have a negotiable instrument. Where is that notice on any of your bills? You're not. So those bills must be negotiable instrument by very definition of the Uniform Commercial Code, Article 3. That is also known as the Bill of Exchange Act. Go ahead.
Yeah. And that is why when you are either doing pay to order or you're using the stamp, you do it on the top portion of it because the top portion is the original bond. The bottom portion is a dividend. I keep that part connected to it as well, because at the point that you break the security by detaching the bottom part, you have now just committed fraud. Like they really don't care that we are committing fraud, you know, and they'll blame it on us if you don't understand what the rules are.
Quite literally all negotiable instruments. And then it goes on to tell you that an instrument is a note if it is a promise, and a draft if it is an order. If an instrument falls within the definition of both a note and a draft, a person entitled to enforce the instrument may treat it as other. And we're going to go over who is the person entitled to enforce those instruments in just a little bit. So Article 3, negotiable instruments, also known as the Bill of Exchange Act, crazy. So can you go to the just Article 3 generally? So they can see all of the parts and all of the things, because I'm just going to go over some of the titles now that we've gone through the definitions, right? So under Article 3, it talks about negotiable instruments. It talks about issue of the instrument. If you can take a guess at what that would be. What is an unconditional order or promise to pay? An instrument payable in foreign money, payable on demand or at a definite time, payable to the bearer or to the order. So you should be able to get an idea of what these things are talking about. Now understanding what payable is, what an order is, who the bearer is. So identification of person to whom the instrument is payable. So it goes through exactly how you identify them. And you'll find most of the time that's the people you're paying, the date of the instrument, contradictory terms of the instrument, incomplete instrument, joint and severability, right? So there's that severability, liability that I was talking about earlier, statute of limitations, notice of right to defend action. So then that's all under the general provisions and definitions. When you look at part 2, this is negotiation, transfer, and endorsement. You can only take a guess as to what that would be. So when you take a look at negotiation subject to rescission, transfer of instruments, rights acquired by transfer. Can you click on that one, 3203? An instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving the person receiving the delivery the right to enforce the instrument. This is what they're doing, right? This is the quite literal definition, and the rights acquired by transfer. Transfer of an instrument, whether or not the transfer is a negotiation, vests in the transferee any right of the transferor to enforce the instrument, including any right as a holder in due course. So this is why any holder of this consumer credit transaction can be held liable, because they get all the rights, including the rights as a holder in due course, but they cannot acquire the rights of a holder in due course by a transfer directly or indirectly from a holder in due course if the transferee engaged in fraud or illegality affecting the instrument. They tell us everything. You cannot spell it out more clear than this. It's right here under the Article 3, transfer of instrument. It tells you exactly what it is, and it tells you all the rules concerning the transfer. So if it was fraud in them transferring it, they cannot accept these liabilities, right? But again, they're doing it in good faith, or at least assumed to be, so they are getting their hands dirty. Unless otherwise agreed, if an instrument is transferred for value and the transferee does not become the holder in due course because of a lack of endorsement by the transferor, the transferee has a specifically enforceable right to the unqualified endorsement of the transferor, but negotiation of the instrument does not occur until endorsement is made. This is why you, go ahead.
I want to back up for a minute, because I don't know if you guys understand how serious B is, okay? Where it talks about the transferee cannot acquire rights of a holder in due course by transfer, directly or indirectly. I'm gonna stop right there. So you guys know, as I've stated, we'll use CarMax. You signed with CarMax LLC. They automatically transferred the car to CarMax Trust. Then they transferred it again. Then they sold it again. So at the moment that the original issuer, which was CarMax LLC, transferred the rights of the contract, they can't repossess you because the transfer was done indirectly and it was engaged in fraud of the instrument itself. That is a defense whenever y'all trying to do what it is that you're trying to do. Because the only thing that they did when they transferred the note, they transferred the security, but they didn't transfer the rights that was in the note where they say we can repo, we can do this, we can do that. At the moment that they transferred it, they lost that because only the original creditor can come after you. Only the original person that you signed. You know how when we told you guys, and everybody says it, that you are not responsible for paying a third-party debt collector because you never had a contract with them. That's the same way it works when you're doing a car, because if your car ever got repossessed and you actually had them give you the repo order, you will see that the person, the company that you signed with is not even the company that put in the repossession. Okay,
so I want y'all to look directly at D. Listen to what she just said and look at D. If a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this article and only has the rights of a partial assignee. They can't do it with partial payment. You see what I'm saying? It's illegal. They're not allowed to transfer that at all. This is why these debt collectors have no rights. You see what I'm saying? Well, that's all I wanted to say, Auntie. You can keep going if you have more to say.
Oh no, I just wanted to show them that, and because even though you gave them permission to transfer it, the contract says that you gave them permission to transfer, but at the moment that they transferred it, whoever they transferred it to don't have any rights. And we know that they're transferring it 1,000,001 times, like even with the thing that I just showed you guys, they had no right to try to force a foreclosure on her because they did not have rights of the contract at the moment that they transferred. That's all. Go ahead.
And this is why, again, the burden of proof, the burden of establishing proof is on you. So if you're going to say that they're committing securities fraud because of the transfer, you have to be able to say see Exhibit A, UCC 2302 or 3203, that specifically says why what they did was illegal and unlawful. So then going very next to endorsement, right? 3204. Endorsement means a signature other than that of a signer as maker, drawer, or acceptor that alone or accompanied by words is made on an instrument for the purpose of negotiating the instrument, restricting the payment of the instrument, incurring endorser's liability of the instrument, but regardless of the intent of the signer, a signature and its accompanying words as endorsement, unless the accompanying words, the terms of the instrument, the place of the signature, or other circumstances ambiguously indicate that the signature was made for a purpose other than endorsement. For the purpose of determining whether a signature is made on an instrument, a paper affixed to the instrument is a part of the instrument. So an endorser is the person who makes an endorsee. For the purposes of determining whether the transferee of an instrument is a holder, an endorsement that transfers a security interest in the instrument is effective as an unqualified endorsement on the instrument. I'm going to read that one more time. An endorsement that transfers a security interest in the instrument is effective as an unqualified endorsement of the instrument. Can anyone raise your hand if you think you can take a guess at what that means? And I'll tell you it again, it has to do with security interest. Raise your hand if you think you can tell me what that means. Okay. Angela, I saw you first. Mojo, you're next. Unless you get it right.
So when they're talking about that, it's in your contract, it says that you assign them a security interest. And so because of that wording in that contract, it when you sign the contract, that's where it takes effect, that what you were talking about. Sorry, I'm driving, so
Exactly.
I can't read my screen.
No, that's exactly right. Regardless of the intent of the signer. Thank you very much. That was perfect. Okay, so if an instrument payable to a holder under that name is not the name of the holder, endorsement may be made by the holder in the name stated in the instrument in the holder's name or both, but signature in both names may be required by a person paying or taking the instrument for value or collection. But signature in both names may be required by a person paying or taking the instrument for value or collection. Then the next one talks about special endorsement, blank endorsement, anomalous endorsement. 3206 talks about restrictive endorsement, all of the different types of endorsement. So when you're looking through Article 3, specifically Section 2, that is negotiation, transfer, and endorsement. Everything you could possibly want to know about that. And then can you go back to the Article 3, just the general sections? So then I want y'all to look again, Part 3, enforcement of instruments. So you want to know who is the person entitled to enforce an instrument? There you go. Holder in due course. I highly suggest you take a look at value and consideration. Okay, overdue instrument. Take a look at what the definition of that is. Defenses and claims in recoupment, claims to an instrument, notice of breach of fiduciary duty, proof of signatures and status as holder in due course, enforcement of lost, destroyed, or stolen instrument. I wonder what that can say, right? So if a person in possession, this is UCC 3309, is a person not in possession of an instrument is entitled to enforce the instrument if the person was seeking to enforce the instrument was entitled to enforce the instrument when loss of possession occurred, has directly or indirectly acquired ownership of the instrument from a person who was entitled when the possession occurred. The loss of the possession was not a result of a transfer by lawful seizure, and the person cannot reasonably obtain possession of the instrument because the instrument was destroyed. Its whereabouts cannot be determined. Its wrongful possession of an unknown person or a person cannot be found or is amendable, is not amendable to service of process. So what this is saying is, if you're sending someone an instrument, any kind of instrument, and it gets lost, destroyed, or any kind of way, they still have an obligation to enforce it. So when you're sending these things to the companies and they keep on telling you, we don't know what happened, we lost it, even though you sent it registered mail, they are still entitled to enforce that instrument because they were in possession of it at the time when the loss occurred, and they were supposed to enforce it in the first place, right? So then you take a look even further. Liability of parties. It's really self-explanatory at this point. Dishonor. So you guys want to know about dishonor, presentment. So what is a presentment? What is dishonor? And notice of dishonor, evidence of dishonor. And then your favorite part 6, discharge of payment. Discharge in effect of discharge. Payment. What exactly is payment? Tender of payment, discharge by cancellation or renunciation, discharge of endorsers, and accommodation parties. So let's take a look at UCC 3602, which is payment, which states here that, subject to subsection B, an instrument is paid to the extent a payment is made by or on behalf of the party obliged to pay the instrument, and to a person entitled to enforce the instrument to the extent of the payment, the obligation of the party to pay the instrument is discharged, even though payment is made with knowledge of a claim to the instrument under 3-306. So, and then it goes on to tell you under E, if you send a payment, it is not discharged as well. But under 3603, the very next code, this is tender of payment, right? This is one of the most important ones too. You go to the very next one. So if tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, the effect of tender is governed by principles of law applicable to applicable to tender of payment under a simple contract. If tender of payment of an obligation of an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of the tender of the obligation of an endorser or accommodation party, because you'll see some people sign by accommodation, right? Having right of recourse with respect to the obligation to which the tender of payments is related, right? So that tells you everything you need to know. If you can get them to admit to you in writing that they are refusing your tender of payment, it's already taking care of the obligation. Already. So this is why everything else. And then can you go back to the Uniform Commercial Code in general and go to Article 8? Every article of the UCC is very, very important. So again, you have the definitions. So these are the rules for determining whether certain obligations and interests are securities for financial assets. It says right here. Can you click on that one? A share or similar equity interest issued by a corporation, business trust, joint stock company, or similar entity is a security. An investment company security is a security. All an interest in a partnership, limited liability, is not a security unless it is dealt in or traded on securities exchanges or in markets. Its terms expressly provide that it is a security governed by this article, or if it is an investment security. However, interest in a partnership or limited liability company is a financial asset if it is held in a securities account. A writing that is a security is governed by this article and not by Article 3, even though it also meets the requirements of that article. However, negotiable instrument governed by Article 3 is a financial asset if it is held in a securities account. That is pretty self-explanatory to me. I think understanding the definitions of why we're saying that these things are securities, because you'll find that what you have is very much fitting these definitions. But it has to be dealt and traded on securities exchanges or markets. And we just showed you a whole terminal where they do that, and they do it thousands of times for 33 years. Okay, so these are all of the rules governing security. So can you go back to Article 8? The general thing, just so they can see all the parts again. Hello, Auntie, you there? You may have stepped away for a second. Okay, well, until she comes back, I will use this chance. Raise your hand if you got a question so far about what we've talked about. Oh, I saw you first. Oh, wait, what happened? The hand went down. Okay, well, this is it. Okay. I just asked you to unmute.
Hello. So my question is, if you have a mortgage and you're going to do the stamp process, whenever you, I guess what I'm trying to say is whenever you send that to them and you send the cover letter, do you let them know that you're aware that they committed security fraud in your note with your instructions? Or are you quoting the UCC in your cover letter as well?
I would do all of the above.
And then when it comes to mortgages are a little bit more complex. You can actually question them under the UCC and under RESPA. The document that I use for a mortgage, if I'm not doing it as a arbitration, is like 17 pages long. They have to answer every question, and it is the UCC and the RESPA mortgage laws that goes with both of them. If you are doing the stamp, that's like mixing processes, because the stamp is actually giving them payment. But if you notice from what I showed earlier today, it's already been paid, right? So you giving them another instrument, they're not going to do nothing but do it all over again. There is an arbitration clause in your mortgage contract. It just doesn't say arbitration. And if that clause is not there, then you can take it to arbitration up under the insurance portion of it, right? And then once you have it in arbitration for their insurance, then you can tie everything else up into it. But if you're going to do the stamp aspect of it, that means that every month you're going to have to stamp the security and send it back into them. And we all know that these people don't always follow the rules. If you are going to use the stamp, make sure you find the trustee and you send it to the trustee. If they accept it, then you're good. If you have to go the UCC route, which is the administrative process, then yes, I will use the UCCs as well as RESPA.
Can you just use the promissory note to do the stamp? I mean, since that's their original security that they sold, does that make sense?
Yeah, it makes a lot of sense. Yeah, you could use the promissory note, because they don't have the promissory note anymore. They burned it.
Okay.
The original note, they burned it, so they don't have it. But it still goes back to you're giving them another security for something that was paid. I know y'all want the easy way out, but it's like, okay, I'm gonna stamp it and I'm gonna keep moving, but then you're still gonna be fighting for the title of your house. You know what I'm saying? They are selling your security into millions of the dollars. Like, when is it gonna be enough is enough? You know, everybody is looking at it that it's just debt is bigger than that. But hey, whatever floats your boat. Yes, you can use the stamp, send it to the trustee, and see if they accept it.
All right.
Or me personally, I would have did an accord and satisfaction on them, but that's a whole nother class for a whole nother day, and I doubt if I ever teach it. Okay, I'm done.
All right. So I really want y'all to pay close attention to some of these things here. Whether endorsement, instruction, or entitlement order is effective. And right here, securities intermediary and others not liable to adverse claimant, securities intermediary as purchaser for value. Can you take a guess at what a securities intermediary is? Vincent, I'm going to ask you whether or not you can answer that question. Let's see if you got the answer. What do you think a securities intermediary is?
I'll take a guess at it. Securities intermediary would be, I would say, would be the bank, or someone who has the ability to come in between to negotiate the security.
Absolutely. The exact definition is a bank broker that in the ordinary course of its business maintains securities accounts for others and is acting in that capacity. Yes, sir. And also a securities intermediary that receives a financial asset, establishes a security entitlement to the financial asset in favor of an entitlement holder, is a purchaser for value of the financial asset. A securities intermediary that acquires a security entitlement to a financial asset from other securities intermediaries acquires the security entitlement for value if the securities intermediary acquiring the security entitlement establishes a security entitlement to the financial asset in favor of an entitlement holder, which that basically just ran itself in circle. But yes, the securities intermediaries are the bank. Now, issue and issuer, right? But I want y'all to pay specific
Before you
attention.
go there, y'all have to understand that the securities intermediary is like this. So Wells Fargo is where you put your money, right? And when they transfer it over to the Treasury to securitize it, to get the Q-sub number, and they give that funds back to you ×2 to your account, Wells Fargo then transfers it out to the intermediary bank, which is Wells Fargo Securities. So every bank has a securities department, which is the the wealth management side, which is why you open the account on the wealth management side, so that you can have a relationship with the primary, which is Wells Fargo, but then also their intermediary bank. And this is how they're hiding the funds. Because when that money goes back into your account between the hours of 2 and 4 every morning, except on Saturdays and Sundays, it goes through your account, but then they transfer it to the intermediary bank, which is their security bank. So that's just like having the indenture trustee and the trustee, right? Because remember, a trust can only deal with a trust, which that's where the intermediary bank come in there. So just always know that when you're going after one bank, when you guys are asking the bank for your accounting on the public and the private side, and they act like they don't know what you're talking about, is because you're talking to the wrong portion of the bank. Only the intermediary bank that deals with securities, because remember, all banks are security transfer agents. Stop looking at them as banks and call them what they are. They are security transfer agents. They are the agent to transfer our securities, to get it securitized and bring it back to us. But because you're minors, they're transferring it out to them, their intermediary bank. So for you guys that have been writing security agreements, first of all, the security agreement is not between you and your straw man. Okay? It's not. It will be between you. If it was me doing it, it would be between my trust, me, Wells Fargo, and Wells Fargo Securities. You have to add all of those in there. You guys are asking the wrong people. You're asking for the right stuff, but you're asking the wrong person. It has to be the intermediary bank, because that is where they're transferring all your securities through. Okay? Go ahead.
Period, point blank. Now, so take a look under part 2. Effect of the signature of authenticating trustee, registrar, or transfer agent. You know what a transfer agent, we know what trustees are, registrars. So that's one that I would take a second look at. But all of Article 8 governs your securities. But specifically, I want y'all to look at part 3 and part 4. So rights of the purchaser, endorsement instruction, effect of guaranteeing a signature. But look at 8307. Purchaser's right to transfer requisites for registration to transfer. I'm about to tell you what it say. Unless otherwise agreed, the transfer of a security on due demand shall supply the purchaser with proof of authority to transfer or with any other requisite necessary to obtain the registration of the transfer of the security. So it sounds to me like you're able to request that accounting on the public and the private. But if transfer is not for value, a transfer need not comply unless the purchaser pays the necessary expenses. If the transfer falls within a reasonable time to comply demand, the purchaser may reject or rescind the transfer. So coupled with everything you've learned tonight, that should have a very powerful meaning to you. But for part 4 of Article 8, duty of issuer to register transfer. And 8405, replacement of lost, destroyed, or wrongfully taken security certificate. And then once again on 8407, authenticating trustee, transfer agent, and registrar. So these are all the terms that you're looking for. So when you're needing to understand more about these things, this is the underlying law. This is where you come to find out. And once you have the definitions down, that takes out half the battle. Because now when I'm looking at authenticating trustee, transfer agent, and registrar, I can see that. But look at securities entitlement, securities account. So this is definitely going to give you the definition of a securities account. Acquisition of security entitlement from security intermediary, assertion of adverse claim against entitlement holder. So anything that you could possibly think to know for these securities, you're going to find under the Uniform Commercial Code. And if you know where to look and what you're looking for, then it makes it so much easier. Look at 8507, duty of securities intermediary to comply with entitlement holder. Duties of security intermediary to change entitlement holder's portion to other form of holding security. So these are all of the things that the person who the intermediary banks, these are the rights and the duties that they're supposed to perform. And if you're finding that they're not performing these duties, which they're not, we've already given several examples of how that's already happened, then what's going to happen is they're going to keep getting away with it. But you have to hold them accountable to the law which they agreed to follow. That's really the main thing. And then
And the
the
only way
last
you're
thing
going to be able to hold them accountable is if you know the law. They wrote it. I know it's a lot of reading. It's an awful lot of reading, but reading is fun, the FUND, mental. Okay,
yes,
like it's a lot. And yes, there are a lot more that is here. Go over this one, nephew. The assertion of an adverse claim against the entitlement holder.
I absolutely will.
That's very important. They're telling you that you have the right to gain remedy from it, but it's not using the USCs. It's using what they go by, which is the UCCs. But can you go in detail about the adverse claim against them?
So an action, remember, action is you going through your proceeding, any proceeding in suit in law and equity. An action based on an adverse claim, click on adverse claim real quick and it'll take you to what adverse claim is. A claim that a claimant has a property interest in a financial asset and that it is a violation of the rights of a claimant for another person to hold, transfer, or deal with the financial asset.
But
Your
because they
cars,
got you
your
as a
homes,
minor, they're acting as the custodian, but it's illegal. Period.
So
this is what an
whether
adverse claim, when you put it in, should be based off of right here.
and notice how, again, it links you right to the definition of adverse claim in there. So what is an adverse claim meaning in this specific section? If it's highlighted like that, click on it, because that means that it has a definition that is unique to that. So you click on there. So it says whether framed in conversion, if you go right back to it, repleven, constructive trust, equitable lien, or other theory may not be asserted against the person who acquires a security entitlement under Section 8501 for value and without notice of adverse claim. So the 8501 is the securities account. Can you actually go to that one? Because that'll locate that. That's going to make it so easy. I actually wanted to go specifically over that. Securities account means account to which a financial asset is or may be credited in accordance with an agreement under which the person maintaining the account undertakes to treat the person for whom the account is maintained as entitled to exercise the rights that comprise the financial asset. Subsection B, because this is all included, except as otherwise provided by subsections D and E. A person acquires security entitlement if a securities intermediary indicates by book entry. That is very key. Book entry that a financial asset has been credited to the person's securities account, receives a financial asset from the person, or acquires a financial asset for the person in land and either accepts the credit to the person's securities account. And remember what the financial asset is. A financial asset is an obligation of a person or a share, participation, or interest in a person or property of an enterprise of a person, which is a type or dealt traded on the financial markets, or which is recognized in an area that is issued and dealt as a medium of investment. 2, any property that is held by a securities intermediary for another person in a securities account has expressly agreed with the other person that property is to be traded as a financial asset. As context requires, the term, it means either the interest itself or the means by which a person's claim to it is evidenced, including a certificated security, uncertificated security, security certificate, or security entitlement.
So look at what he just said. I want y'all to think about y'all monthly statements that come. It was a book entry to be credited to your securities account. So for every account that you have, T-Mobile, light bill, water bill, you got the public side and then you got the security side. You've heard us say that that is actually a dividend payment. It's based off of the interest that they made in that 4-week period. And what they gave you was a statement of an accounting. The top part is the bond. That is the financial asset, the top part. The bottom part was what was actually credited to your securities account. This is why they come in a positive status. Is because they are just telling you that this is how much they actually put into your securities account. But because you opened it as an agent for a principal and the principal is a child, they took it. It's the best way you can think about them bills. It's done as a book entry.
Can you click on the financial asset right there? And then scroll down right here to registered form as applied to a certificated security means a form which the security certificate specifies a person entitled to the security. So this is why we say you put the name of the person on there. It specifies a person entitled to it, and the transfer of the security may be registered upon books, maintained for that purposes by or on behalf of the issuer, or the security certificate so states. This is why we are telling you to send it registered mail so that it may be registered upon the books of the United States. Now, security, except as provided in section 8103, means an obligation of an issuer, share participation, or other interest that the issuer has in property or an enterprise of the issuer, which is represented by a security certificate in bearer or registered form, or the transfer, which may be registered upon books, is maintained for that purpose on behalf of the issuer. And it says under part 2, which is one class or series, or by its term divisible into a class or series of shares, which is a type dealt with or traded in securities exchanges or markets. Again, is a medium for investment and is a security governed by this article. And it gives you the definition of a security certificate representing a security. Security entitlement means the rights and property of an interest in an entitlement holder. And an uncertificate security is a security that is not represented by a certificate. And this is all from the 8102, which is the definitions. So if you read nothing else, the most important thing that you're going to understand or need to read is the definitions from all of these portions, because this is the vocabulary that they're using. You would not understand what a registered security is or even what a security is in terms of this if you just go into reading it and don't take the time to read the dictionary that they give you in the beginning of it.
And the UCCs are your defense if you are trying to do a billing error. This is what you use if you want them to take your billing error serious. These are what you use. Don't keep talking about it's a positive status, okay? You can let them know that you knew it was a security based off of UCC this. You know that you are considered an investor into their company. We're all investors in every company in which it is that we have a security with, right? You're investors. We all investors, okay? So when you guys are doing billing errors and you're trying to gain their attention to create your account in the proper status that you are gaining off of your security, the UCCs is what you will use in writing the letter for your billing error, okay? The ones that we're going over. I'm probably going to make this a 2-part class because it's a lot. And I understand that people attention span is only so long. So we probably lost y'all about an hour ago, and it's okay. We people, like, and I know what it is because it's so much, especially when all you guys have been hearing is the USCs and this, that, and the other, but you want to know why your billing errors are not working because they don't understand that language. The only language that they do understand is the UCC as well as the UCCC, which is probably why this is going to end up being a 2-part class where you can tie in the federal UCC with your state UCC. And I'll actually go over how you will construct the letter, what UCCs to use, how it is it needs to be written if you guys are wanting to gain their attention, because it is a lot. So this will definitely be a 2-part class because we want to make sure that you guys are knowing how to properly use the UCCs that we're going over. Yes, every last one of them are important, but the ones that Caleb is pointing out to you guys tonight is what you're going to need if you plan on getting any remedy when it comes to any of these companies, period. Okay, go ahead, nephew.
Absolutely. And again, because we were originally planning to do the UCCC as well, but I'm already, 2.5 hours in. So, and I still got one more part to do. So it's definitely going to need to be a 2-part class just for the sake of equity, because I don't think y'all want to be here for another 3-4 hours. And that's what it's gearing up to be if we continue on. But all of this information I know is a lot currently. It really is. And so,
I'm
but
going. I'm trying to get
you
to
have
it.
your
Yeah.
securities accounts. You have all of that. And so all of the rules that you're going to need and all of the things I'm showing you, I'm trying to show you how it all relates back to, well, this is what the UCC says, and this is what they do in direct contrast addiction to it, right? So that's really all it is. And the last part that we're going to cover, right? So again, read all of Article 8. Security entitlements, registration. This is why we're telling you the things that we're telling you. You want to know why we're telling you to do these things? This is why we're telling you to do those things. So again, it's not Caleb and Tamika said. This is what the Uniform Commercial Code said. So make sure that you look at your state's Uniform Commercial Code as much as you look at the federal, because as much as they are uniformly adopted, there are going to be slight differences and changes between the federal UCC and what's going on in the individual states. And what's going on in the individual states in certain cases is going to be more important, because the pull between federal law and state law is most of the time federal is going to supersede, but when federal law does not provide the same protections of state law, then state law is going to supersede it. So you have to use whichever one is going to give you the most protection and is going to be most fit for your purposes. But Article 9, so we've dealt with the general provisions of the Uniform Commercial Code. We've gone into a little bit of the negotiable instruments, which was Article 3. And we've gone into the investment securities, right? Which was Article 8 and everything to do with that. But now we're dealing with Article 9, which is secured transactions. Right. So you're using securities, you have a securities account. Now, what about the transactions? What are the rules governing transactions? Because every single set of things needs its own set of rules. The investment securities need their own set of rules for how investment securities are supposed to be handled and what type of accounts. But then the transactions have their own other set of rules. So you start again with the definitions and the index of definitions in Article 9. Of the short title. One moment. Okay, so like I was saying, secured transactions. Ooh. Definitions. So when you immediately jump into the definitions, account, except as used for account means right to payment of monetary obligation, whether or not earned by performance, for property that has been sold, leased, licensed, or assigned, or otherwise disposed of, for services rendered to be rendered, for a policy of insurance to be issued, for a secondary obligation to be incurred or accrued, for the use or hire of a vessel under charter or other contract arising out of the credit charge or information of contained use for the card, winnings of the lottery, blah, 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 blah. So these are all definitions of accounts. And everything that you're doing with that deals with money is an account. That is the main thing that you're going to take away from reading that right there. An account debtor means a person obligated to pay an account on shadow paper or general intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument includes part of shadow paper. Now, shadow paper means a record or records that evidence both a monetary obligation and a security interest in specific goods. A security interest in specific goods in software used in the goods, a security interest in specific goods in the license used in the goods, a lease of specific goods, or a lease of specific goods, and a license of software used in the goods. In this paragraph, monetary obligation means the monetary obligation secured by the goods owed under a lease of the goods. Sorry, I'm doing a lot of reading. I'm trying to find where I last read.
Where you want me to go down to, nephew?
You click on. I was gonna have you click on. You scroll down to shadow paper.
Yeah. Here we go.
Term does not include other contracts involving, okay, the use of hire vessel records that evidence the right to payment arising out of the use of a credit charge or information contained on with or for use of the card if a transaction is evidenced by records that include an instrument or a series of instruments. Then you go back. Oh no, I was still in the definitions index. That's the account. That is the account debtor. Okay, the accounting, right? So right here, authenticated by a secured party, indicating an aggregate unpaid secured obligations balance as a date of not more than 35 days earlier or not 35 days later, identifying all the components of the obligation in reasonable detail. So when we're talking about getting the GAAP accounting, the accounting, if you could scroll back up to accounting, Auntie, the accounting is that financial forensic audit. And that's exactly what it's saying. That's why you had the report that actually showed, it was shown what it was 35 days before the report and then what it was going to be later, which is why you saw how it went up from like 418 to 500, right? So, but it has to be by an authenticated and secured party, identifying the components of the obligation in reasonable detail. That is exactly what it's speaking of, right? A financial forensic audit in its purest form. That's going to be the best accounting that you can provide because it's all the information in regards to that. So then you have co-signee, commodity contract, all of the definitions, deposit account, electronic shadow paper, all of these definitions underneath this Article 9, and even going down to liens, lien creditor, you have promissory note in here. Specifically, an instrument that evidences a promise to pay a monetary obligation, does not evidence an order to pay, and does not contain any acknowledgement by a bank that the bank has received a deposit for a sum of money or funds. All of these definitions are extremely important. What is a transmitting utility, right? It tells you specifically a person primarily engaged in the business of operating a railroad, subway, street, or trolley bus, transmitting communications electrically, electromagnetically, or by light. Transmitting goods by pipeline or sewer, or transmitting or producing and transmitting electricity, steam, or gas, or water. But B is the one you want to look at. Transmitting communications electrically, electromagnetically, or by light. So those
now,
are
do y'all understand that you are a transmitting utility? Because we had nothing but electrical beams. So when he said that B was important because they're talking about you, they're talking about you. We are a transmitting utility.
And when you get to a UCC 1 and you see it asking about a transmitting utility, that makes a little bit more sense, don't it?
Yeah. It was something else I wanted to go over that I just seen. 9-103.
That was the one. That was the next thing I was going to. The purchase money, and I got the 16 CFR 433.1. That's the next thing.
Yeah, and if y'all go pull 16 CFR 433.1, you know how everybody say Congress never defined loan. They did. It's called a money purchase loan. Okay.
This is what I wanted to get to.
At the definition of a money purchase loan, you ask yourself, did that happen? When you went and got that card, did they physically give you a check? You were supposed to. You had a check there with your name on it. The dealership took it, right? Because you ultimately signed and co-signed for the dealership. So stop saying that they didn't define loan. They did. It's called a money purchase loan. And it is the security interest that's within the money purchase loan. So 9-103 is extremely important for you guys to understand the meaning of it and how it will really assist you when it comes to defeating these people. But yeah, go ahead, Nathan.
So this is the TILA tie-in, right? because again, you have the truth in lending disclosures. And when you look at that, the disclosure that it gives you in 433.2 states that any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained pursuant to or with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. So that notice should make a whole lot more sense with all of the foundation, because you have to understand they became a holder in due course when it was transferred, right? So they are all liable, and you can assert against them the goods or services pertain, and you can get all of that money back, all of that money that belongs to you. It says that you can get it back because you can assert it against any holder of it, and they all held it and they all made money off of your signature. So that is exactly what that definition is. Now, it says purchase money collateral. So if you got a purchase money loan through TILA, when you financed your car and you got a mortgage, that's good or software that secures a purchase money obligation incurred with respect to that collateral. The purchase money obligation is an obligation of an obligor incurred as a part of the price of the collateral for value given to enable the debtor to acquire rights or in the use of collateral if it is so in fact used. So then purchase money security interest in goods. Purchase money security interest in goods is a purchase money security interest to the extent that the goods are purchase money collateral. Same thing with software, co-signer's inventory to purchase money. This is important. The security interest of a co-signer in goods that are subject of a co-signment is a purchase money security interest in inventory. Application of payment in a non-consumer good transaction. So in a transaction, other than a consumer good transaction, if the extent to which a security interest is a purchase money security interest depends on the application of payment to a particular obligation, the payment must be applied in accordance with the reasonable method of application to which the parties agree. In the absence of the parties' agreement to a reasonable method in accordance with the intention of the obligor or manifested at or at the time before payment, in the absence of an agreement to a reasonable method and a timely method of manifestation of the obligor's intention in the following order: to obligations that are not secured, and if more than one obligation is secured, to obligations secured by purchase money security interest in the holder in which those obligations were incurred. And then, so that ties into G, which is the burden of proof in non-consumer good transaction. In a transaction other than a consumer goods transaction, a secured party claiming a purchase money security interest has the burden of establishing to the extent which the security interest is a purchase money security interest. So you have to prove that what you got was a purchase money security interest. And the way you do that is with that TILA disclosure, because it's on every single one of your contracts and it all times ties in. So this is why all of the contracts, all transactions, all things are covered, right? And then you see that the very next one, control of deposit account. So can you go to that one, Auntie? That is also very important. Y'all want to take over your bank accounts? Everybody asking about that class. That is control of the deposit account.
Which one you want me to go? I'm sorry.
It's the very next one, 9104. If you then a secured party has control of a deposit account if the secured party is the bank in which the deposit account is maintained. The debtor, secured party, and bank have agreed in an authenticated record that the bank will comply with instructions originated by the secured party directing the deposition of the funds into the deposit account without further consent by the debtor. The secured party becomes the bank's customer with respect to the deposit account. But if you are doing it through an agent or a minor, then you aren't, the secured party is not ever becoming the bank's customer. The secured party does not have an authenticated record or of instructions, which is your security agreement. It all ties together. And it's all here. Article 9 of the UCC. That's why I specifically focused on them, because we're talking about securities, negotiable instruments, and general provisions. So investment securities and secured transactions all play into the same thing. But if you want to take control of your deposit account, you must have that agreement between you and the bank. No other way around it. And if you don't have that proper agreement, which none of you have that agreement right now, then you are not in control of that deposit account. And if you're not in control of that deposit account, then who is in control of that deposit account? It
And that's
tells you
why the
that.
account says Jane Doe and John Doe on there, because only a living soul, a living person, can have that position at the bank, which is why you have to have a living estate trust. And as he said, a security agreement. So the security
now-
agreement that you do tells the bank what they can do and what they can't do, what you will accept and what you won't accept. But it also has to be based off of their security agreement on file with the Security Exchange, as well as the Trust Indenture Act that we keep telling y'all need to go read.
Now, can you go back to the general provisions of Article 9? Because now that you have all of these definitions locked in, I'm about to blow your mind with this last part here, because this is it. So control of the deposit account, scroll down. So effectiveness of security agreement, attachment of security interests, rights of parties to security agreements. So you want to know the rules for security agreements? That's where it is. Perfection and priority. You keep hearing us say they have to have a perfected lien. Otherwise, it's not correct. This is the law governing perfection and priority. The law governing protection and priority of security interests, agricultural liens, priority of security interests in goods covered by certificate of title, priority for basically the law governing perfection and priority for every type of account that you can think of underneath that section is what that is going over. So those are the rules for that. I strongly suggest reading over those. Then you have the rights of the bank, right? The rights of third parties, and then filings. You have questions about your filings through the UCC, filing office, contents of financing statement, records of mortgage as a financing statement, name of debtor and secured party, indication of collateral. You want to know how to fill out a UCC 1? Go read the filing article of Article 9 of the UCC, and it will tell you exactly how you're supposed to fill it out, what constitutes filing, effectiveness of filing, effective indexing errors, duty of the filing office. Then the one part that you all want to know most about, part 6, default. What happens when one person goes into default? What default is? Rights after default, judicial enforcement, co-signer or buyer of accounts, shadow paper, payment of tangibles, or promissory notes. So if you want to know what to do when they go into default, this is where you're going to go look, and this is where you're going to find it. So rights after a default, judicial enforcement, cosigner, or buyer of accounts. So after a default, a secured party has the rights provided in this part, except as otherwise provided in section 9602, may reduce a claim to judgment, foreclose or otherwise enforce the claim, security interest, or agricultural procedure by any available judicial procedure. If the collateral is documents, may proceed as to either the documents or the goods as they cover. So,
and y'all need to, because y'all hear secured party creditor all the time. There is no such thing. You are either the secured party or you the secured creditor. And by reading this, you understand that you are the secured party, correct? And those are the rights that you're going to uphold as a secured party. It was your signature that secured the security that they are transferring. Please stop saying secured party creditor, because there is no such thing. There's one or the other. You also see where it says that it has to be provided by agreement of the parties, which means you and them both have to agree to the terms. So that's why they have you sign those contracts. You're saying that you're agreeing. If there's a part in the contract that you do not agree with, you could have changed it, especially due to the fact that your signature is the only signature that is on the contract itself, because they have 30 days to send you a completed contract, and it had to be signed by the lawful person, which is always the trustee. Always the trustee. But please understand, guys, that you guys are not the creditor. You are the secured party, and the financial institutions are the secured creditor. Okay.
absolutely. And then, did you go right back to the general part 9, article 9, secured transactions? And then part 7, transition, which was the last one I wanted to go after. Part 7 at the bottom.
You said 907.
Mm-hmm.
Which one?
No, I mean part 7, the very bottom, 9701.
Oh, 9701.
Or this that whole part. So effective date, security interest perfected before effective date, security interest unperfected before effective date. So well, they don't have it up on here. At least not the 9, but they got that one.
Because if y'all notice that when it talks about a perfected lien or security and an unperfected one, it remains an enforceable security interest only after 1 year. So if you didn't have your car for 3 years and they repoed you on the 4th year, that security interest, due to the fact that it was an unperfected lien, was only effective for 1 year. Hopefully you guys will see why using the UCCs is what you need in order to gain your proper remedy. You need something else on this page, nephew?
Nope, that was it. And that actually wraps up all I wanted to talk about with the Uniform Commercial Code, because those are the rules for your secured transactions, investment securities, and having more context as to what those words mean will help guide people into like, okay, I'm looking specifically for information regarding this in the UCC. But like I said, I recommend you go back and you read the entire thing. The entire UCC, even if you don't think it's going to pertain to you or your situation, the practice and reading the legal jargon it's you can't be beat. But it all applies and it's all important. Because what we didn't cover is Article 2A, which is leases. Article 4, which is bank deposits and collections. Article 4A, which is fund transfer. Article 5, letters of credit. Article 6, bulk transfers. Article 7, documents of title. Right? Everyone want to know more about titles? That's Article 7. And then Article 8, investment securities. Article 9, secured transactions. But that pretty much wraps up what, the UCC, at least an introduction to the UCC. And again, I strongly recommend you go and read it. And I hope after this, you see the importance of it and you're starting to be able to see like, okay, when we say securities fraud, this is exactly what we are referring to. And this is exactly why it is fraud, according to the rules that they agreed to. And as you can see, it says the Uniform Commercial Code is not a comprehensive set of laws. It is a comprehensive set of laws governing all commercial transactions. It is not federal law, but uniformly adopted state law. And the reason why it's essential is because when you enter into contracts in any jurisdiction, it has to be enforced the same way.
Period. So for you guys, if this is your first time paying attention or understanding the importance of the UCCs and you just been stuck on the USCs, it's like starting all over almost. But just, I want you to look at every contract as securities. If you look at it as a security, then you'll understand how it's supposed to move and the rights and the remedies that you have up under it. So now the UCC is on a federal level, okay? Because you have everything that's federal and you have state. Then each individual state has the Uniform Consumer Credit Code that also ties into the UCC, which we will, as I said, this is going to end up being a 2-part class because it's already 10 o'clock where I'm at almost, so it's 11 o'clock where some of you guys are at. I want you guys to digest that some. And then when we bring up the UCC with all of the states, then you guys will be able to tie it in together. I tell you, they act a whole lot differently when you are talking to them and you say you guys committed securities fraud, okay? Because with securities fraud, you can now contact the security exchange, okay? Just like on a post that Caleb put up, I've reposted it, the post that he did about the is that a brain freeze? Give me a second to come back.
We've been on here a little too long.
The 10K and the 8K form. When we
Yes.
showed on there where they talk about the discharging of the debt and everything that's in their security agreement that they put on file is in relation to the UCC. You see why you use that? I'm telling you, you start talking about security fraud to these people, you get to being on the phone with some big people because they know that if you file with the security exchange and you file correctly as a whistleblower, you'll get 10% of the net worth of the entire company. And somebody going to jail and somebody's going to be hit with more taxes than a little bit. This is why this article of the UCCs are so much stronger when you guys are attempting to do your remedy. In the next class, it will be a second part class to this, and I'll send everybody out a link for it for the next class. I'll figure out tomorrow what day it'll be on, and I'm going to tie in the UCCC, and then we will show you guys, because one of the biggest issues everybody have is how do we draft this up? What exactly are we supposed to say? You know, so we'll go over that within the next class so you guys will know how to attack these companies the proper way. But if anybody is attempting to do a billing error, if you're already in arbitration or anything, switch it from the USCs. That's not going to get you nothing that everybody is using. That's why it's not working any longer, because everybody's using it. Okay, they already know which way you're coming. But you get to talking about securities fraud is a whole new attitude that they give you. If you can pull their security agreement and read it and correlate it with the UCC, and you're going to be like, darn, they really did tell us the entire time. You know, it's just about reading properly. We're here to show you how to properly read and understand their language, because unfortunately, they deliberately taught us a totally different language with totally different meanings, and we're using it as a blanket for everything, and we being left out in the cold, because that's not how it works. They've done a good job at distracting us. I know some of these people online talking about the 15 USCs, they agents, because that's where they want people to think and they want to go. So yes, the United States is paying your bills already, guys. They're already paying them. Your bank is taking it from you, point blank, period. So now you're going to learn how to be able to conduct business with your bank on the proper side so that you can get them to give you your proceeds off of the securities that you're already selling to them. Because the law says that until you come and step up and say you're no longer a minor, okay, this is up under the Uniform Transfer Minors Act. The Uniform Transfer Minors Act. It says that as soon as the minors step up and say, hey, I'm grown, that's that age of majority. I'm a grown person. When it comes to the bank, it is putting your living estate trust on file, right? It says that all of the securities that the bank has made on your behalf, they have to give you every one of them without delay, with no penalty and no tax costs. Because we all know that trust, especially for minors, they cannot tax it. What happens is after 3 years, when you don't claim these things, they give it to your State Department. That is why they have that lost money for every state, right? Because after 3 years, they give your money to the state because they say that you abandoned it because you didn't know that it was there. When I say all of these systems tie together, but the key pieces of winning in this system is learning the UCC. And before me and Caleb done, y'all gonna know it. Y'all gonna be spitting UCCs the way y'all hear 15 USC 1692, and the government's supposed to pay my bills. Y'all gonna be around here like, hey, they transfer my security interest and this, that, and the other, and I'm supposed to have this, that, and the other. You know what I'm saying? And honestly, all of my arbitration cases that I win on a regular basis, I win them because I go in as security fraud. I use the USCs to, if I need it, That's just like, you know, a little cherry on top, you know, just to add a little extra. But I get them and I'm getting them to do settlements and settle out because I go at them with securities fraud and that scares them. You know, start looking at Wells Fargo as a security transfer agent, Bank of America, security transfer agents. Go pull their security agreements. Read what they stated and they signed to say, this is what I'm gonna do. That's why when you put a stamp on them bills and you send it to the trustee, like the guy from the last class, and they went on ahead and paid it because they said, wait a minute, he know a little something. And that stamp said pay to the order. And if their book entry, it could say pay to the bearer, but either one of them is going to get it taken care of. But the point is, we don't want to have to stamp nothing every month. We supposed to be living freely and happily, and that's it. But we'll get y'all there. And like I said, when it comes to the mortgage, it's a little bit different. It's a little bit more to it, but in all actuality, it's still all the same. We voluntarily gave them permission. Now go take it back. Any holder of your contract, y'all see what her contract is worth. So when it says that you can get 2 times the amount of the contract, for you guys that hear me say it all of the time, you see that 2 times the amount of her contract is how much? Because it's the full contract. It ain't just what you got on that paper, right? So that's why the one lady, they settled out with her for 18 mil. You know, I don't know where she at now because that's been some years ago, but that's what she settled out for. I would have too. Y'all probably would have never seen me no more for $18 million. You know what I'm saying? But it's securities fraud. And that is what get them to treating you like you are a threat to them. We got to stop being scared of them. And we got to show them that we understand their systems. We understand their words and we're coming for them. And me and Caleb is going to help you guys get there. Okay.
The only reason that they seem so big and bad is because they know for a fact that you don't know the rules. You can't win at a game if you don't know the rules. But they never thought that little old you would outthink them because they told you your whole life that you never were capable of anything extraordinary and that law was outside of your grasp. If y'all want to study like me, this is what I would do if I were you, right? When I was in your position, if I just got onto this class and I heard it, what I would do is I would take 2 weeks and I would go and I would read through the entire Uniform Commercial Code over and over, read through the entire thing. Because any questions you have right now, I guarantee you, if you read through the entire thing and you give it some time and you let your brain settle, you go back over your notes, you're not going to have those questions. You're not going to have not one single question because it answers everything. There's a reason why it's so long. There's a reason I didn't go too far into Article 9 because y'all saw how long it was, right? You got to go through it and you got to read each of those rules and you have to understand them and internalize them. After you have read and studied that for 2 weeks, go ahead and take those new eyes and take a look at those 8K and 10K forms. With those new eyes, with the new definitions locked in your brain, take a look at that and see if it means something different to you. Read things with your new lens, right? Always change the lens in which you're reading. And I guarantee you, you give it just 2 weeks reading it, read it over and over, internalize it, and you will start looking at things differently.
Period.
You will
So that's
start
what we're
looking
going
at
to do.
things differently.
You guys will get a copy of this replay. I said I wasn't going to give out my replays no more because that's how my video got put on YouTube. But I'm not about to penalize everybody because one person. I'm not going to do that. So I'm going to give you guys 2 weeks. I will get the replay out to you guys as soon as possible. It will be before the weekend is over.
If you have not received the replay, it has not come out. If I have not posted a video letting you know that the replay is out, it has not come out. I guarantee you didn't miss it. I do not want 100 emails asking me when this replay is coming out because it is a courtesy and you will have the time, the same amount of time from the time that you get it to look it over. So it don't matter when you get it because you're going to have the same amount of time. So please do not spam my email.
Please, mine either or on my post. So we'll give you guys 2 weeks to digest, be able to stop and pause this video, pull the points that we pulled out and understand them. So when it comes to the next class, you already got the UCC Now just adding in the UCCC and knowing how to execute, because that's, you guys are getting a lot of information. You're welcome. You guys are getting a lot of information, but you need to be able to know how to take this information and then execute. Okay. And that's what we're going to do in the next class. So I'll give you guys 2 weeks to go over what we went over tonight, get y'all notes, get y'all questions. And like we said, if you listen to it more than once, if you read it and read it based off of their definitions, like when I was in y'all position, I started with flashcards. I went through every definition. And because as y'all see, these UCC definitions are totally different than the USCs, right? They're not the same definitions because you're in a totally different article, okay? That will get you guys prepared. And then the next class, we'll go over the UCC, and then we'll show you guys how to formulate your documents and how to use these to your advantage. Okay. Sound fair? Is that cool? And that's what we'll do. You guys
I
will
think
automatically
that's,
get a link. Go ahead.
I was gonna say, I think that's perfectly fair. If I were you, I would personally watch this video at least 4 times. But again, that's just me. Like, I don't really do anything special, but again, I take the information I'm given and I dive deeper and I study it and I dissect it. I would like a class that's this long, 3 hours. It's probably going to take me 6 hours to watch it one time. So it's like you're going to have to dedicate 24 hours plus to, you know, studying this. But it's the same thing with school, right? You go every day in a week for so long, and those hours eventually add up. And I know it seems like a lot, but the amount of value that you're getting into yourself is unmatched, because money is all about energy. And when you have to understand, our eyes are literally absorbing light all of the time. When you, the more information that you read and observe, you quite literally are becoming denser. You see what I'm saying? And that density will attract things to you simply by reading. This is why successful people, they say, oh, they read 60 books a year, or, you know, they read so many more books than the average person a year, because they are increasing their density and their value. And you can do the same thing.
Yeah. And that's how I got here. I've been reading, like I literally read every day. My children will tell you that for 10 and a half, 11 years, all I do is law all day. I do it so much that they know it, you know, but it has paid off because I now know how to talk to these people, and they give me the respect that I am to be given because I know how to communicate with them. And once you can communicate with them, then you're able to get remedy from them, and it lies in the UCC. So we're going to get away from these USCs when it comes to your securities. And if nothing else make you want to go back and look at this video, think about the beginning of the video where I literally just showed you guys how much they are making off of your signatures. Every last person on this call are freaking billionaires. But because you are a minor and didn't tell the bank what to do, they sitting high riding in jets and shit. And we over here trying to figure it out. That's not fair. It's not fair at all.
With
And
your
then you'll know
money.
how to represent with your money. Like it's literally your money. And then they're paying off the government, like all of the government officials that's in office, because they're public office, you can see who their donators are. And every last one of them are getting billions of dollars from the bank. Why y'all think they paying them? They paying them not to tell us that technically that all is funds that belong to us. Okay. So on that note, I know y'all got some hands up. I know y'all got some questions, but I promise you, if you go back and look at the video, those questions that you have, you will not have after you watch the video. And
That's what
if
I'm
you
saying.
have any additional questions, write the questions down. I'm thinking about doing something like an email where y'all can send the questions and we'll just pull them. I'm trying to figure that part out because I like to try to get to everybody. Y'all know that, but we just literally can't. You guys will get a a link for you guys to be able to join the next class, because it will be part 2 of this class. No, it is not a cost for that class if you are in this class, and no new people can come to this class because you guys have already started. Listen to the video, take some notes, reread it, and we'll show you guys how to incorporate the state level of the UCC with it, and then how to execute. Okay. And for that, nephew, if you don't have anything else to say, you guys have a very wonderful evening, and I will see you guys on social media or however, and I will get those links out the recording out to you guys as soon as possible.
All right, and I don't have anything else to say, so please start reading that over. When you get the replay back, watch it over several times. I guarantee you 99% of your questions will be eliminated. And yeah, y'all have a good night.
All righty, have a good night.